itu উঠাব লাগিব তাই দিয়া বৰ কষ্ট হয়নি
Yeah, Lordship, I beg to mention item number 17.
17.
Yes, Lordship.
What do you want?
Kindly, this matter may be listed on 21 July.
21 July.
Yes, Lordship.
2020 matter.
Yes, Lordship. Lordship, we have taken.
A matter of 2020. First, tell us that. In 2026, why should we adjourn a matter of 2020? That to a writ petition.
Lordship, we have taken consent from other.
Consent is not the matter.
Lordship.
Why should we adjourn?
Lordship.
Matter is a 6-year-old.
Lordship, conducting council is from Guwahati.
Let the matter reach. We are not adjourning matters of 2020 for this kind of case. Sorry. Yes, madam.
Okay. Ma'am, my lordship, I beg to mention item number 20. This matter, yes, ma'am. This matter will be listed on 16 June, my lordship. I have taken consent from the other side.
16 June. What is the difficulty today? What is the difficulty today?
I have some difficulty.
Then why 16 June? Today is what?
Second.
Today is 2nd. Why 16th? Have it in this week? Day after tomorrow?
Lordship, I'm for the state lordship. I'm having some difficulty.
Then 9 June. These are all matters. 9 June.
Okay, right.
9th. On a request made on behalf of the state, matter is adjourned to be listed on 9 June for hearing.
May I please, Your Lordship? I beg to mention item number 18 and 19, Your Lordship.
18 and 19.
Your Lordship,
Yes.
yeah, in this matter, Your Lordship, earlier Mr. P.J. Sekia, the senior counsel, was the conducting counsel. However, Your Lordship, due to preoccupied schedule of the him, Your Lordship, the appellant has engaged other counsel, and I've been instructed that Mr. K.N. Chaudhary will be appearing in this matter, Your Lordship. So kindly, this
He can appear online. What is the difficulty? Nowadays we are promoting online.
Yes, Lordship.
Friday.
Kindly, this matter is listed on 15 June, Your Lordship.
Well, I appear on behalf of private respondent here.
Yes.
There is a difficulty that these two honorable judges have already rescued this matter, recused this matter.
Rescued
No, recused this
or
matter.
recused?
Yes, honorable
Recused or
justice.
recused?
Recused.
Recused.
Yes,
Not rescued.
yes, yes.
Okay.
So, my lord,
Not 15th. 15th, you know this bench?
No, Your
Did you know about the bench? Which bench? 15th?
15 is Monday and it's not a DVD. Usually we have only on
No,
Tuesday.
no. He's saying that two of the honorable
Yes,
judges
honorable
cannot
judge,
take up.
Okay.
Justice Atte and Justice Habung, they have already. So, my lord, this matter may take up on Thursday.
Next week, who's there?
Till now we have not got the roster. Lordship.
Roster is not. Justice Das is there. Here, Justice Das along with whom?
Actually, 1 week we got only the present roster. Both of them. We have not got the updated one. Yesterday,
See, there's some difficulty with the other normal bench which is available here. So that is it. We will we'll fix this when? Monday next. Let us try on Monday next.
Yeah.
The city council can appear online. Mondays and Tuesday, Wednesday, Fridays are otherwise online days. Okay? 18 and 19. What's it? Monday is a single bench day.
yes, we
And
have
Tuesday.
Tuesday only.
Tuesday.
Yes, my lord.
Okay. A request for adjournment has been made on behalf of the appellant on the ground that there is change of counsel.
Yes.
Correct? On the other hand, the learned counsel for the respondent has expressed urgency. So we have also noticed that these matters are long pending. Correct? In view of the above, list on 9th of June.
Lovely.
9/6.
Lordship, I beg to mention item note 21
21.
on behalf of PP Mehdi.
Yes.
We have taken consent from other sides and matter may be released after 3 weeks.
Why 3 weeks? There are criminal appeals of 23. Man is behind the bars. Cannot adjourn matters like this. You are mentioning on behalf of the PP.
PP Mehdi,
PP Mehdi is appeared from whom?
appellant.
Appellant. His name is not showing. Nonetheless, when we are not adjourning for such a long time, we'll have it on Tuesday next.
Next week.
Next Tuesday. Okay. A prayer for adjournment has been made, but his name is not there in the cause list. Are you sure that he's there in 21?
Lordship, actually it is Signal Jirang.
Signal Jirang, yes.
Yeah. He's
Because-
out of station
You
and
said
he
PP
asked,
Mehdi. Okay, a prayer for adjournment has been made on behalf of the appellant. Para. A list on 9/6, same date.
Great, please, Your Lordship.
Yes.
My lord,
Yes,
I've mentioned item number 24, my lord, I have taken consent of the other side. I appear for the petitioners. My lord, the matter was fixed last Thursday, but it was declared a holiday and it has come up today. My senior, Mr. M.K. Chaudhary, would like to conduct the matter, my lord, by physically appearing before Your Lordship, my lord. So he has prayed that the matter be listed on 16th or 18th, my lord.
What is the matter about?
This is against the election, which was
Election.
Student election
What is there to be decided now?
my lord, some guidelines had to be laid down as per the Supreme Court judgment, my lord. That is all. The interim order was vacated.
Elections
my
are
lord.
over. Is there any election in the pipeline now? There is no election.
No, my lord, but we will pray for certain guidelines to be laid down in the judgment for future elections, my lord. That is all. That is what we will be arguing for, my lord.
Okay, when do you want? 16th?
16th or 18th, my lord, as per your lordship's convenience.
16.
On a request made on behalf of Sri M.K. Chaudhary and the senior counsel for the petitioner, matter is adjourned to be listed on 16/6.
My lord.
Sri M.K. M. Kato, learned, year 4,
My lord, I'm for the private.
and Sri N. Ratan, learned AAG, and Sri M. Kato, learned counsel for the private respondent are present.
My lord.
Item number 1 and 2.
Lordship, in this item number 1 and 2, Lordship, learned AG is appearing for the state, Lordship. This matter was in particularly item number 1. The matter was fixed for hearing on the maintainability of the PI, Lordship. But in the meantime, some development came up. The counsel for the petitioner, he withdrew himself, and he was directed to intimate the petitioner so that a new counsel can be engaged, Lordship.
You are the new counsel.
No, my lord, I'm for the item number 2.
2 is connected. Same
Yes.
subject.
We are connected,
It's
Lordship.
connected.
So if the subject matter is before us,
Yes.
we can decide to, and automatically one would also be decided. What is the issue involved?
Here, Lordship, the rule has been challenged.
Rule
Particular act has been challenged, Lordship.
in the PIL.
PI, Lordship.
What kind of act?
This is District-Based Entrepreneurship Act, Lordship, 2016.
Okay. So when do you want?
Lordship, learned AG,
What matters?
all matter, Lordship.
The madam's matter is 21. The subsequent matter is 24.
Lordship.
But we have to decide 21 matter
Yes, Lordship.
without delay. When
Yeah.
can we have?
On 16, Lordship.
But 16, ensure that the AG is there.
Otherwise, I'm told that he's having some health issue. AG, learned AG.
Then you argue. We'll try to accommodate.
Close.
These are all matters.
All matter. Then it may be fixed on 16, Lordship.
Madam, 16.
Okay, fine.
A request has been made on behalf of Sri I. Chaudhary, the learned Advocate General, who appears for the state in these cases. A request has been made a request for adjournment. Yeah. Para. Considering the above, matters are adjourned to be listed on
16 June.
16th of. Okay. 16th is Tuesday.
Yes, Lordship, it's Tuesday.
16 is Tuesday.
Yes. Item number 3.
May it please your lordships. Lordship, this is writ appeal, lordship, challenging the order dated 11/11/2005, my lord.
It was listed earlier,
It was listed earlier, it's fixed for final disposal today, my lord.
final disposal today.
Yes, my lord.
Yes, other side, yes.
My lord, last time I was verbally directed to take the my lord, instruction. My lord, what happened to my lord, the directives issued by the landed single bench, my lord, pertaining to fresh NIT, my lord. My lord, I have the instruction, my lord. So in compliance to that single bench order, fresh NIT was floated, my lord. 3 bidders they participated, and the successful bidder that will be recommended to the government for final approval, my lord. And that is not challenge.
That is not.
That NIT is not under challenge, my lord.
Madam,
So perhaps a new course of action has come up, my lord.
we need to challenge this process.
Lordship, our case is that on 27/11, notice on interim was issued in this writ appeal. Without taking leave of the court, they started
Is
with.
there a requirement to take leave?
No, there is no any interim order. I'm sorry.
Unless there is an
Notice.
interim order,
Not-
your submission would have force if there is an interim order in spite of which.
Lordship,
They were under, somebody has advised them this, you cannot say this is a wrong advice. Ideally, they could have informed this court. If they have not done, it's not illegality. You have to inform this new cause of action if you are interested to pursue. Otherwise, this appeal will become infructuous.
Lordship.
If tomorrow, even if you allow your appeal, in the meantime, the work will be allotted and done by somebody else.
But there is a stay, Lordship, in last week's order, there has been stay in the new, NIT has been stayed by the honorable court.
You have already challenged.
No, we have not challenged because it was not been finalized
Then stay by whom?
by this honorable court in Lordship to 26/5/2026 order of this writ appeal.
Which order?
26/5/2026. Which it has been taken, we deem it appropriate to direct the respondent authorities not to finalize the tender process till the next date of listing.
My lord, that's why, my lord, we have, my lord, not issued the, my lord, work order, my lord. Otherwise, process is completed. There is no any embargo, my lord, that we cannot proceed with the NIT.
Considering that the judgment order is issued whereby the respondent to direct the issue of appeal. Not to finalize the tender. Okay, there is an embargo, not to
My lord,
finalize.
Not to finalize. My lord, there is no any embargo, my lord. So for process is concerned, my lord.
Also, yes.
Process, my lord, we have completed. We have not, my lord, issued the award, my lord. That part is there, my lord.
But the court has taken cognizance in the last
Lordship.
order period. We can hear the matter.
Lordship.
You can hear it now? Yes,
Yes, what is it?
Lordship, the fact is that
But the only problem, my lord, is single batch, my lord, we sell together, my lord. That is the only problem, my lord.
Respondents have not been served.
Respondent, my lord, I think they prefer not to appear, my lord.
Lordship, we have served thus.
They have served.
They accepted, but they have not appeared, my lord.
Files. Please don't record. Just a minute, please. 8-5. Is there any order
Lordship,
of,
Lordship, we have filed the affidavit and court took note of it, Lordship.
oh, there's an order 14/5/26. In view of the above, notice upon respondent 7 to 10 is deemed to be complete. 14/6. 14/5/2026. And 14/5 now sufficient time has elapsed. They have not appeared.
No, Lordship.
Could you take it? Appear on hold. Your writ was dismissed.
The writ was dismissed.
Earlier, who had appeared on behalf of the private respondent?
For the private respondent.
Mr. Muk Patel, if I correctly remember, my lord, London Senior Counsel,
The
my lord.
judgment,
Judgment is page 227, my lord.
Titi Tara,
For the respondent, we were the respondents
you are the respondents.
in the writ petition.
Oh, the writ was allowed.
We were a successful bidder. We started
was allowed.
Also for several
Oh, writ
months.
was allowed.
Writ
You are not the
was-
petitioner.
No, the petitioner, my lord.
Oh, M. Patil was the,
Lordship for the writ petitioner.
yes, what do you do? Tell us best course of action. If you want, we can hear it.
Lordship,
It has to be heard.
Lordship, I'll argue the matter, Lordship. Lordship, the fact is that Lordship on 10/12/2024, a tender notice was issued by the 10/12/2024. A tender notice was issued by the
NIT.
NIT. Was issued by the Deputy Commissioner of Pakke Kesang District for appointment of PDS wholesale nominee cum carriage contractor for the year 2025 to 2027. Lordship for carriage of PDS items through the district by land route.
Yes.
The appellant, along with several other contestants, they participated in the bid, and thereafter approval was
How many bidders were there?
Lordship. Total there were at least contesting there were 5. Along with the appellant, there were 4 others. So
Around 5.
around 5 bidders.
Okay, then
Approval was granted by the Commissioner Food and Civil Supplies on
regarding
Re-
approval for what?
Lordship's first recommendation was given by the Tender Evaluation Board on 10/1/2000.
In your favor.
In my favor.
When was it done? When was the
On-
evaluation done?
10/1/2025.
What was the basis of the evaluation? Technical, financial, what?
Technical and financial board. It
Both,
was,
two
one,
bid system.
one bid.
Two bid system.
2 bid system. Lordship, thereafter, the respondent number 7 herein, who was also the writ petitioner, he challenged the recommendation
You were recommended.
as recommended,
You were found to be technically responsive,
responsive.
and your financial bid was held to be the L1.
Yes, Lordship.
Petitioner selected.
Selected, recommended. And this recommendation was challenged by the writ petitioner in WPC 95 of 2025.
This the selection recommendation was done on which date?
On recommendation on 10/1/2025.
10,
1 to
24. Which page, madam?
recommendation at page 91, Lordship, of the appeal memo.
Okay. Thereafter, the writ petition was filed.
A writ petition was filed challenging this recommendation by the Tender Evaluation Board. But in the meantime, approval was also granted. Therefore, they withdrew the writ petition, which is WPC number 95 of 2025. They withdrew the writ petition without taking any liberty from the court. WPC 95 of 2025.
No, initial was 95 of 2025.
Yes, Lordship.
Hmm.
It was closed as infructuous.
WPC was closed.
By order dated 28/7/2025.
28 or 20?
28, my lord. 28/7/2025 in WPC 95 of 2025.
Closed as infructuous.
Closes infructuous and without taking any liberty to come back to the honorable court again. Without taking
Since approval was granted, so it has become infructuous.
infructuous.
Can we see this order? Which page?
Lordship, this order is not in which, but I have a copy of the
Could
order.
have
Lordship.
given this, okay, doesn't matter then.
Thereafter, Lordship, approval was granted on 12/2/2025 by the Commissioner Food and Civil Supplies.
12 to 25.
Yes, approval to the recommendation was
Okay.
granted.
Okay.
Thereafter, this writ petition, the impugned writ petition, this is WPC. Lordship, 111 of 2025 was referred by the writ petitioner, again challenging the recommendation as well as the approval.
Yes.
Now, Lordship, this writ petition was allowed, but in the meantime, since we were the successful bidder, we started our work for several months. Thereafter, after the writ petition was allowed, we were ousted, and thereafter, Lordship, we preferred this writ appeal against the order dated 11/11/2025 in WBC 111 of 2025, which is the impugned judgment, Lordship.
First, you tell us what were the grounds urged by the writ petitioner and accepted by the learned single judge for which WPC 111 of 25 was allowed.
Lordship, the writ petitioner preferred the writ petition, citing several grounds. However, Lordship, the tendering authorities, Lordship, it brought on record several documents which the writ petitioner had alleged that we did not submit, but by the affidavit it has been brought on record that we had submitted all.
So the ground was that your it was incomplete.
Lordship.
And that was the main ground.
No, Lordship, I'll come. Lordship, first ground for allowing was that the writ petitioner has locus to prefer the writ petition. And second was that
No, we are asking about the grounds which the writ petitioner has urged. He'll not urge about locus. He'll urge about some defect on your part.
defect.
What are the defects?
Lordship, many defects were there,
Yes.
but the honorable single judge
What are
took
the
note.
defects? What are the defects?
Lordship, several defects, including Lordship, most of the clauses of the NITA, which Lordship was denied by the tendering authorities. They brought on record also that we have submitted all the documents. But Lordship, two grounds which the honorable single judge took note of was that Lordship, one was that Lordship, the bank guarantee which we had submitted was not from a nationalized bank, but it was from the Arunachal Apex Cooperative Apex Bank. And the other one was that Lordship, the earnest money deposit was not submitted in the name of the cooperative society, appellant cooperative society, but it was submitted by the chairman of the cooperative society, who is not a stranger.
The petitioner is a cooperative society. You are a
Cooperative society. These two grounds, Lordship, were grounds in defect in form, according to us. But the writ petitioner, my lord, they themselves were not ineligible because the writ petition.
You were R what? Appellant was R what?
Response 7 in the writ petition.
Appellant R7.
R7. These two defects were taken note of by the honorable single judge.
What was the difference in the rates? Rates?
In rates, Lordship, I'll just come.
The financial bids were open.
It was open.
So what was the rate in which you were given and what was their rate?
Lordship, in the rate, Lordship, and rate has not been specifically, Lordship, mentioned in the approval.
But you have, what was your rate?
Lordship, I'll just copy that. Lordship, I'll just bring this instruction, Lordship. Because,
You
Lordship,
need to
here,
have-
because in the comparative statements, it's mostly about the technical aspects, Lordship. On the technical aspects, the
No, it is not their case that they were found to be technically non-responsive.
they were technically non-responsive, man.
There was a,
Major technical,
no, was it the finding of the evaluation committee?
yes, Lordship.
They were held to be technically
Yes, Lordship.
non-responsive.
Yes, Lordship. And substantial defects, Lordship. In
And
their-
that was also a part of the challenge.
that was not challenged because since we were successful, we didn't challenge that, but
No. You need not challenge.
Lordship,
You are the successful bidder.
Lordship.
The petitioner, we are asking what was the rate of the petitioner vis-a-vis your rate?
Lordship.
You said that you not have immediately, you do not know.
Yes.
And the next question was that, was the petitioner was found to be technically responsive? Did they come up to the stage of financial evaluation?
Lordship, here, Lordship, most of the decisions, all the decision was made on the technical aspect, madam.
So you said, madam, that there were around 5 bidders, including you.
Lordship.
You were finally recommended, approved. So
Lordship.
that is the subject matter of challenge by an unsuccessful bidder.
Lordship.
That unsuccessful bidder, writ petitioner, was unsuccessful in the technical stage or in
Technical
the.
stage, my lord.
So did he challenge his holding him to be non-responsive in technical stage?
Lordship, that he did not, because he challenged the recommendation, withdrew the writ petition.
Page,
Thereafter-
where is the prayer of the writ petition?
Lordship, prayer of the writ petition, Lordship.
Where is the writ petition? Which page?
Prayer will be at page 84 of the appeal memo,
84.
Lordship.
Bid evaluation.
He challenged the bid evaluation report dated 10/1/2025, which was already withdrawn in the earlier.
No, that is okay.
Thereafter,
Where is the recommendation? Which letter?
recommendation, my lord, is at page 91 of the appeal memo.
Page 91.
91.
What is the name of the writ petitioner?
NNMPS, Lordship.
NNMPS.
Serial number 2.
And your name?
Lordship, I am serial number 3, Papu Hote, MPCS.
No, the petitioner was not held to be technically non-responsive. They were held to be technically responsive. Both of you and the petitioner.
Lordship, but minimum number of shortfalls.
No, both you, after examining the documents of the above mentioned firms, means which firms? There are 3 firms,
Lordship,
including Papu Pani. And our firms, Messrs. Papu Hote, that is you,
Lordship,
and MPCS. MPCS is the writ petitioner.
Lordship.
Yes.
Is found to be with minimum numbers of shortfalls in comparison to the others. That means your defect was the minimal.
Minimum.
So both of you, hence the board recommends Papu Hote and MPCS limited to the Deputy Commissioner Pake for initiating further necessary action. So it's not the case that writ petitioner was held to be technically non-responsive.
Lordship.
They were technically responsive. So, but you had said that they were held to be so where is your final recommendation?
Final recommendation, Lordship, is at page 89, which is the approval by the Commissioner.
Thank you. 89.
89. The approval is recorded to the writ appellant.
So this we have not understood, Mr. Abam, you have to explain. Both the writ petitioner and the respondent number 7, who is the appellant before us,
My lord.
were found to be technically responsive. Now, where are the papers by which the order at page 89 could have been passed? Order dated 12/2/2025, selecting the present appellant to be the successful bidder.
My lord, if your lordship see the recommended state, my lord, minimum, my lord. My lord, page 19, my lord.
19,
91, my lord.
91, yes.
Yes, my lord.
Yes.
After examining the documents of the above mentioned firm, MS Papu Hote is to be found with minimum number of shortfalls.
Yes.
This could be the reason, my lord, why.
No. We cannot give that meaning.
Well-
Please read. See, there are 4 entities rather, who were evaluated. Papu
Correct, my
Hote,
lord. Correct,
and
my
then
lord.
NPS,
MPS, then the one more, my lord.
and Bandhan.
Bandhana and yes.
Now, after examining the documents of the above mentioned firms, Messrs. Papu Hote, that
Yes.
means the petitioner, the appellant,
Appellant, correct, my lord.
and MPCS, that means the writ petitioner,
Yes, my lord.
is found to be with minimum number of shortfalls
My lord.
in comparison with the others forms. Hence, board recommends Papu and MPCSS to the deputy commissioner for initiating action. Now,
Correct.
when both were recommended,
Yes, my
either
lord.
you give to both,
Or
if you
to,
give to one,
My
then
lord.
he has to in the technical, in the financial bid, there has to be some consideration.
my lord, here, my lord, perhaps the approving authority, they again, my lord, re-examine between, my lord, Papu Hote and MPS, my lord. Now, who has the more minimum, my lord,
Oh, no, where is that evaluation?
my lord, that evaluation,
But Mr. Nabam, the question will arise, where is the scope of further evaluation by the deputy commissioner? Once the board recommends, the deputy commissioner will only see the rates. Whose rates is the L1?
my lord, here, my lord, perhaps, my lord, the technical, my lord, technical, the documentation, my lord, documentation, my lord. So documentation is technical, it was sent, my lord, perhaps with the, obviously, it was a two-bit system, my lord, technical and financial, my lord.
See, our present consideration is slightly on a different tangent.
My lord.
Writ petitioner had alleged that madam's client did not fulfill many requirements. We are not on that
My
absolutely.
lord.
We see that there is a recommendation at page 91, both on behalf of the appellant as well as the
One more, my
writ
lord.
petitioner.
Correct, my lord.
Now, writ petitioner and appellant both were recommended.
Correct, my lord.
Now, how do you give the work? Either you split the work or give it to the one who is L1. Where
L1,
is
my
the
lord.
consideration that appellant was L1? There has to be some minute, some consideration, some meeting or some application of mind.
The publication is the rate is given here.
Madam, do you know and how were you selected?
Lordship, if we come to page 91,
Yes.
Lordship, here, there are four corporate societies. Lordship, for number 4, board has not accepted.
Hmm.
Number 1,
Not
2, 3
accepted.
remains.
One
Out of-
one is also not accepted.
No,
Papu one is not accepted.
not accepted. Even Lordship 2 is also not accepted.
Two is accepted.
Lordship,
Yes, two is accepted.
2 is not accepted, my lord. No. 2 and 3.
No, what is an MPCS?
MPCS is Lordship, number 3.
No, no,
Lordship, MPCS is the appellant.
MPCS is applicant, no?
No, down below, page 91,
After exam.
Papu Hote, MPCS are two different entities,
No,
aren't they?
Lordship, Papu Hote MPCS is one entity. Number 3.
Is one entity.
Lordship.
That is the problem.
Multi-purpose- Papu Hote multi-purpose.
That is the
corporate society.
confusion, my lord.
We are
Oh,
one.
This is one entity, my lord.
The appellant was recommended. Thereafter, that was approved by the commissioner. Number 2 was never recommended, Lord.
Oh. There's some confusion regarding the use of expression
Expression, my
MPCS.
lord, correct.
There's a comma also.
Lordship,
Well,
comma, and that's all.
My lord, this Papu Hote Multi-Purpose Cooperative Society, that is the full.
And what is the name, their name? NNMPCS.
And
And then
You are
MPS here.
Papu Hote MPCS.
Lordship,
Multipurpose. Cooperative Society.
multi-purpose.
Okay.
But writ petitioner was never recommended, my lord. Thereafter, it was approved and we started our work, my lord.
Okay. There's some confusion. Yeah. Okay, understood.
Now, Lordship, coming to page 91 again, there's a note below. It says the board has strictly prioritized on vehicle and godown. That is the basis of their decision. Now, Lordship, we were recommended. Our Lordship, our only shortcoming which they had found was that our insurance expired on 3/1/2025, which is bound to expire at one point of time of the year. But at the time of submission, we had a valid insurance. But Lordship, writ petitioner had several Lordship substantial defects. Therefore, we were recommended, we started our work. Then WPC 111
Let us read the order of the Honorable Single Judge,
Lordship.
page
At 227 it starts, Lordship. And the judgment order starts, effective portion says it from page 230, the judgment starts. Lordship, from page 21 are the observations.
Just a minute, please. Judgment dated
Lordship, 11/11/2025.
Where are the findings?
Lordship, findings from page 240, paragraph 21.
240.
Lordship. Shall I read? Lordship.
Yes.
This court has considered the submissions made by the learned counsels for both the parties and have also perused the documents on record. This court finds that on the issue of maintainability, the matter has been
Maintainability has been held in favor of the petition.
in favor of the petitioner.
Okay, no
Lordship.
problem. Okay.
But Lordship, here I have my submission. Lordship, the writ petitioner being ineligible, Lordship, did not have any locus to prefer the writ petition. Had he been an eligible bidder, he would have had the locus. But being an ineligible bidder by preferring the writ petition and thereafter writ petition being allowed, now Lordship, now he has converted this Lordship entire proceeding to become eligible in the Lordship to become eligible in the meantime, and thereafter Lordship participate in the fresh proceeding. He was never eligible at all, Lordship. Therefore, Lordship, he did not have the locus, Lordship. Just because he participated does not mean he has the locus. He has to be eligible to be to have the locus to file a writ petition challenging Lordship the work Lordship allotted to the appellant, Lordship. Now, Lordship, the next ground was that, Lordship, from paragraph 23. It said, in applying the above principles in the instant case, this court finds that the petitioner had
And
participated
it is on the maintainability. That is
on the maintainability.
on that we have seen. Thereafter,
Lordship, paragraph 24, on the aspect whether the selection process followed by the respondent authorities is found to be sustainable. It is seen that the respondent authorities had issued a tender notice by so-and-so dated 10/12/2024 for bids from interested and registered cooperative societies of Pakke Kesang district for appointment of PDS wholesale nominee cum carriage contractor in respect of the Pakke Kesang district for the year 2026. It should be Lordship 25 to 27 for carriage of PDS items. At paragraph 4 of the tender notice, the following items and conditions were given. Lordship, then all the conditions are given. Lordship, should I read the conditions or not? Lordship, paragraph 25. At paragraph 4 of the tender notice, the following terms and conditions was given. Earnest money of ₹2 lakhs only in the form of deposited call receipt / fixed deposit receipt in favor of the Deputy Commissioner Pakke Kesang district. The earnest money will be refunded on finalization of the tender. 2. Financial soundness certificate from a nationalized bank mentioning the value of contract and that the tenderer is capable of undertaking for a minimum amount of ₹50 lakhs only. No due certificate from all banks should be furnished by the tenders along with the financial soundness certificate. In the event of two registered cooperative societies quoting similar rates documents, preference shall be given to the registered cooperative society having experience in transportation of food grains in Food and Civil Supplies Department with Corporation of India, and details of experience should be attached with the tender, and next option will be other government stores. Income tax clearance certificate, income tax exemption certificate, as the case may be. A duly signed copy of these terms and conditions should be enclosed with the tender in acceptance of the same. Details of vehicle owned by the tenderer, along with attested copies of registration certificates and road permits, minimum 4 trucks, or attested copies of lease agreement executed before magistrate with attested copies of registration certificates and road permits with taxes paid up to date. ST certificate, permanent residence certificate, date of birth certificate, education qualification certificate, and details of other infrastructures available, including godown and office. A copy of business turnover certificate from RCS that the society has been running business turn of at least 1 crore in the last 3 years, copy of up-to-date audit report, valid registration certificate of cooperative society. It is seen that the respondent authorities have accepted the recommendation of the bid evaluation report proceedings dated 10/1/2025 in the selection of the bidder for appointment of PDS wholesale nominee cum carriage contractor in respect of Pakistan district to land. The contents of the board proceedings was thereafter reproduced, my lord, in the order. Lordship, the same one, which was at page 91, which I've already gone through. Now, Lordship, coming to page 246, paragraph 27. A perusal of the board proceeding dated 10/1/25 shows that all the 4 bidders have certain deficiencies in their documents, which were submitted along with their respective bids. The bid of the respondent number 7 was selected on the grounds that he was having the least number of deficiencies in his bid documents. However, this court finds that there is no mention in the tender notice or in the tender documents that the bid evaluation board is permitted to declare the bid of such bidder to be valid if such bid is comparatively having lesser number of defects than the other bidders. It is also seen from information obtained through RTI that there were other shortfalls in the tender bid of the respondent number 7, which were not highlighted in the board proceeding. But Lordship, the tendering authorities, they have already brought on record the affidavit. Everything was fine, Lordship. Whatever was in the RTI, Lordship, though it was considered, but everything is on record that all the requisite documents were filed by the applicant, Lordship. This court finds that there are 2 deficiencies in the bid of respondent number 7, which are most noticeable.
Madam, where is that order by which WPC 95 was closed?
Lordship,
Page 28, not 20, 28/7/25 order.
Lordship, I have got the order, Lordship. I have another copy.
You had participated in new process also? No.
No, Lordship.
Yes, Mr. What about the petition, which has been, relied upon by the.
Learned single judge.
Lordship, one citation was regarding the law. Lordship,
Express that by giving the information.
Lordship.
So, on a slightly, what do you call it? So not very transparent. The way,
Lordship,
and it's more on assumption that on the amount of defect, here you want to have the minimum. But what minimum other defects the other parties have, those have not been spelled out. Elaborately in the evaluation assessment.
Lordship,
With the evaluation sheet. That is the main reason. And certain people that is cited on fairness,
Lordship,
including Bharat Code.
Lordship, at page 30, Lordship. Bansinghar construction versus hard coking was relied upon. Here, Lordship, in this judgment, defects of both the parties were the same nature. Lordship, here, Lordship, in our case, Lordship, it is very distinct from that fact because, Lordship, in our case, our defect was that, Lordship, one is that bank guarantee was not from a nationalized bank, which, Lordship, the tendering authorities used their discretion. Lordship, they were satisfied with.
Where are your statements with regard to this? We have filed an FNN opposition.
Lordship, Lordship,
There are two main defects which they have pointed out. One was with regard to your regularity.
Lordship, Lordship.
How have you dealt with belief and how this case has dealt with the business?
Lordship, our submission was, Lordship, our Philippine position of 207. Lordship, Lordship, at page 212, Lordship. Government. 212, Lordship, the authorities have stated that the earnest money of rupees 2 lakhs, only of private respondent number 7 was deposited in the form of deposited receipt, fixed deposit in favor of the Deputy Commissioner, Pakke Kesang District through the account of MSHT Enterprise and submitted to the tendering authorities as his earnest money. Lordship, HT Enterprise, my submission is that is not a stranger. He is the chairman of the cooperative society. HT Enterprise, Lordship. There is no clause specified that earnest money ought to be submitted from the bank account of bidder in terms of the terms and condition of the tender. Clause 4.1 of terms and conditions of tender says it has only been mentioned that earnest money of rupees 2 lakhs only in the form of deposited call, fixed deposit receipt in favor of the Deputy Commissioner, Pakke Kesang District. Therefore, the tendering authorities have accepted the EMD of the appellant, Lordship. HT Enterprise. This is the enterprise of the chairman of the cooperative society. And also there was no mention in the clause. Lordship, but Lordship, there's Lordship, entity.
It is not in the account.
Lordship, but
It is
Lordship,
in the name of an enterprise.
yes, Lordship.
He may, as a matter of fact, he may be the proprietor or partner, we don't know.
But-
Per se, HT is not a part of the respondent number 7.
Yes, Lordship. Here, Lordship, one is that in clause 4.1, it's not specifically mentioned as to who will submit. And secondly, Lordship, the authorities were satisfied with the earnestness. And dominant purpose is served because, Lordship, in case they have any doubt regarding our earnestness, they get their, Lordship, the refund from the money from this account. Therefore, they were satisfied, they used their discretion and accepted this defect, Lordship, which is a defect in form again, Lordship. This is not a substantial defect.
No, this is a substantial defect, madam. How can a different entity, if you go strictly, if, yes, if the chairman's private account was used, then perhaps your submission would have some value, some hold. This is, HT is a different entity altogether.
Lordship.
Maybe it's owned by the chairman, but it's not the chairman. HT does business on its own. HT had given the money. So how do you differentiate between HT and you? The immediate question is aroused whether maybe it is actually HT would be doing the work, not a cooperative society. These are meant for cooperative society.
Lordship,
Your
this-
competitor is a cooperative society. You are a cooperative society.
Lordship, this aspect, Lordship, the tendering authorities were satisfied. Because ultimately, Lordship, the purpose.
That is what exactly we are trying to extract from you. This is the version of the tendering authority,
Lordship.
not your version. You may say give any justification, but whether this stand would be sufficient.
Because otherwise, Lordship, my submission will be that the purpose is served, Lordship.
No. Madam, it's not a serving of purpose. There is not the question of money being deposited. Who's depositing the money? That is the entire purpose, that you have to show your own earnest. Somebody else cannot say, no. That means he'll be doing the work. Otherwise, this submission of yours cannot be accepted. Anyone can do any work through somebody else's name. You got my point?
Lordship.
It's not a question of the deposit, the amount. It is a question of who is depositing, in whose name. It's not in the name of the chairman. It's in the name of some message HT Enterprise. Incidentally, the chairman may be the proprietor or partner. We do not know. Why HT had come in?
Lordship, this. But otherwise, Lordship, since the respondent authorities did not have any, Lordship, issue regarding this, therefore, Lordship, the same was not rectified.
And your stand. Let's set the better.
That's why, my lord, I mean, well from my lord, as we sell together in a single bench. Now, is in division bench, it's very difficult to deviate from what I submitted before the single bench. But
two and two, number one.
Well,
Only because the tendering clause said that you have to deposit EMD. So therefore,
but
except EMD is deposit.
correct, my lord. But in tender process, everybody knows, my lord, that what is the role of EMD, my lord. This is the main role of any NIT, my lord. Correct, my lord. And nationalized bank. We all know that.
The bank part we can accept.
My lord.
That whether it's a nationalized bank or Apex, Arunachal Apex,
My lord.
they may have the discretion.
My lord.
But here,
The EMD itself, my lord.
deposit, what is has the Honorable Single Judge dealt with this aspect?
My lord, yes, my lord.
How?
If your lordship see, my lord, paragraph 25, my lord. This is the terms and condition. Then observation, my lord, page 246, my lord, para 28, my lord. 246, my lord, para 28, my lord. Perhaps this could be the reason, my lord, the recommendation of tender, my lord, the evaluation, the landed single bench was not satisfied with us, my lord.
At 246.
246, my lord, para 28, my lord. First defect, my lord, EMD, my lord.
Yes.
First notable defect is the tender is that the respondent number 7 did not deposit the AMD, the earnest money deposit on his own name, but the earnest money was deposited by so and so. This court find is hard to accept so and so.
This finding you cannot interfere with this finding. Let us see
My lord.
their averment in the repetition regarding this.
My lord, the petition, the file addition.
Which starts at which page?
The petition starts at page 39. '62. Page 62 is a repetition.
Experience certificate, random submission.
On page 61, 62.
It too. Yeah, 62 page 19.
My lord, page 61, my lord, paragraph 13, my lord.
Yeah, 61 last, it continues to 62.
Yes, my lord.
Internal is 19.
Right.
Madam has just shown.
Hmm.
Clear requirement has been made. Our views are oscillating.
Now, my lord,
Views were in favor of the appellant, now
now, my lord, the present situation like this, my lord, in compliance with the land single batch order, my lord, the fresh NH was plotted, process is completed, my lord, only the recommendation, the approval is only awaited, my lord. That is-
because of the orders, key order.
Yes, absolutely, yes.
Absolutely.
We thought you had a case, madam, and we would have, but there is something for which we cannot.
But Lordship, in this, Lordship, I have my submission.
Yes.
Lordship, in 4.1, it's not specifically mentioned, Lordship, that is clear from the clause of the tender. And
That you
Lordship,
you do not interpret clause of a tender in this manner.
Lordship, but Lordship, another thing which has to be seen, Lordship, we live the corporate way, Lordship. Ultimately, who has submitted, Lordship? It's the chairman of the cooperative society. He has shown his earnestness. The form may be different. Form,
HC Enterprise and the chairman is the same person.
Lordship, the
You do
chairman,
not you lift a corporate veil when there is a confusion.
Lordship.
Now here another entity has given. Why not the chairman? Why not the petitioner?
Because Lordship, otherwise, Lordship, they.
Now there has to be some good reasons why the petitioner or the present appellant could not give 2 lakhs rupees. It's only 2 lakhs.
Lordship, for the purpose of earnestness, we had-
It might give a wrong signal that somebody else is trying to do the work in the name of a cooperative society. In fact, that is what is happening.
But-
Maybe that is also happening in the other thing, but it cannot be apparent like this.
But Lordship, otherwise, Lordship, the decision was taken on the basis of the vehicles and godowns. Lordship, the petitioner, Lordship, did not have the adequate number of vehicles, did not have a pollution certificate, did not have an insurance. Lordship, if they were selected, Lordship, the entire Lordship purpose of the NIT would have been, Lordship.
What if they have prayed at page 85? They have not prayed for giving it to them. They have prayed for fresh evaluation.
Lordship, only in this aspect, Lordship,
They are also very clever in drafting the petition. They have not asked for giving the work to them. Go for fresh evaluation, which they have done ultimately.
otherwise,
And somebody who has been selected,
My lord, one packet.
maybe another,
Yes,
sister,
madam.
another sister of yours.
Another my lord,
It's-
form, my lord, packet kesang multi-purpose cooperative society.
Not-
Oh, multi-purpose
Not
cooperative
a
society.
sister of HT.
No, my lord.
Okay,
no, Lordship.
maybe. Okay, fine. Madam, sorry, will not be able to agree with you.
Well, Lordship, one more Lordship argument which I have, Lordship. Since Lordship, the writ petitioner was not at all eligible, they came, Lordship, at the very related stage when we had started our work. Now, Lordship, now they have got an opportunity, Lordship.
No, that submission of yours would be relevant at the time of moving.
Moving,
Now,
madam.
it's gone too far.
Too far.
Lordship, otherwise we had
Delayed
started our
approach,
work.
delayed
Lordship.
approach in an appellate stage after an order has been passed by the honorable single judge. That will be irrelevant.
Lordship, I have three judgments, Lordship.
On what?
Lordship, this is a discretion of the tendering authorities as to whether a clause is substantial or ancillary.
Which Shilpi, Central
Lordship,
Court,
Lordship Poddar, Lordship,
Poddar,
firstly 1991.
Fernandez,
Poddar, the Lordship Central
Central Court,
Coalfield and Lordship
MP,
NG projects.
NGP.
Lordship Poddar, Lordship at paragraph 6, Lordship. It is saying essential conditions of
You are
eligibility.
not citing Fernandez.
No, Lordship, since fund is covered, Lordship. And others which are merely ancillary or
Yes,
subsidiary.
name. Poddar citation.
Lordship, 1991, volume 3, page 273. Extra copies.
1991, pre-SCC
Volume 3, SCC, page 273.
273,
273, paragraph 6, my lord.
Poddar.
Lordship, as a Lordship,
Then next,
ancillary substantive, Lordship, next is
this
2000
is on discretion.
on discretion as to whether the clause is substantial or ancillary. It is upon the respondent tendering authorities, my lord. Next is 2022, volume 6, SCC, page number 401, paragraph 29, my lord.
2022,
Volume 6, page 401.
name,
Lordship, sorry, Lordship,
name,
Lordship, sorry, this is 2016, volume 8, SCC,
NG,
Lordship Central Coalfields.
Central Court, okay.
In 16.8, SCC 622 at page
16,
volume 8,
8,
SCC, page 622.
Central Court.
Colvin, paragraph 48. Again, Lordship, whether term of NIT is essential or not is a decision taken by the employer, which should be respected, Lordship. Lordship. And Lordship, the next is 2022, volume 6, SCC, page 127, NG projects.
NG projects have been explained later. This is because of the specific amendment of this a specific relief effect, insertion of 1H, what
Lordship.
6H or what was it? After the amendment.
Lordship. Lordship, you also whether, Lordship, at para 17, question as to whether term of a contract,
41H, after amendment of the specific relief effect.
Lordship, whether term is essential or not is to be
This has
viewed
been
from the
explained
perspective,
later on.
Lordship, of the employer.
NG's strict has been diluted. NG's paragraph.
Lordship, paragraph 17, 21, 22, and 23.
Oh, NG, why are you the scope of judicial review?
Lordship, because it has to be seen from the perspective of the employer whether a term is essential or not. And here 4.1, Lordship, they have interpreted, Lordship, they have used their discretion tendering authorities and they accepted our submission, Lordship.
Okay, anything you'd like to say?
My lord, since this PDS, my lord, is a supply of food grains, urgency is there, my lord. So your lordship may allow us to open, my lord, or my lord, to give the final approval for the fresh NIT, my lord, that which have already carried out, my lord. Because process is almost completed, only my lord, approval is left out, my lord. And these things also, my lord, the petitioner, my lord, the appellant, they are very much aware, my lord. They could have challenged that process, my lord.
Lordship. Lordship, one submission. If your lordship pleases to dismiss, Lordship, at least an opportunity may be granted to us to at least participate in the fresh tender.
What precluded you from participating?
Lordship,
Portion is almost, it's already completed, my lord. Only the approval is left on, my lord.
Lordship, this
You should have
writ
participated.
appeal was pending, therefore we did not participate.
Without prejudice to the result in the writ appeal. You should have participated without prejudice to your rights.
Because otherwise notice on interim was issued, therefore, Lordship, we did not participate, Lordship.
Mr. Dasgupta, what matter? Hearing matter?
No, well, I am a little caught unaware of about listing of item number 8 and 10.
So you'll be taking time.
I will be taking, in fact, we have come for some other matter in the single bench.
Okay.
Suddenly we have come across this in the list.
Okay. And Mr. Dasgupta, same matter. Five is what?
My lord, 8, 9, 10, my lord, this will take long time, my lord. This is also, my lord, tender matter, my lord. It went to Supreme Court and Supreme Court observation, again returned back.
Five is for what, Mr. Dasgupta?
For admission, hearing
Tender matter.
tender matter.
Oh,
It's
fresh
all
matter.
tender matter.
Fresh matter.
Five is-
First time.
Five is press, no, it's for admission, no?
Coming for the first time.
First time.
No,
For
it's
Second time.
other
taken up
court, no?
for hearing a final disposal. 5 minutes.
You are for whom?
For
Correspondent.
You are the writ petitioner.
Yes.
It's a state appeal, my lord.
Or writ was allowed. And the state has come up for appeal.
Yeah.
Okay. Again, tender matter.
Tender matter.
No, why we're asking, because we want to accommodate the lawyers coming from outside. We have to pass the judgment in the court. It will take around some time, so that is why. Your matter, we'll take it up another day. We'll give a date of your convenience. Okay. Mr. Dutta, what is your matter in the single bench? This
Yes.
court or
Yes,
my
yes.
sister's court?
Your lordship.
Okay, we'll try to sit. And Mr. Senior as doctor,
What about?
more senior as doctor, not senior as the more senior as doctor.
Time to let go.
Mr. Dasgupta.
Okay, okay.
My lord, your lordship, my lord, item number 8, 9, 10, my lord.
More senior but younger as well.
By all means.
By all means.
All compliment.
Yes.
Well, item number 8, 9, 10, my lord, can it be listed in next available batch, my lord?
8, 9, 10, who's the lawyer?
Yeah, he's there.
Okay, 8, 9, 10. Okay, it will take some time.
It will take some time, but otherwise also, my lord, I did not know about list.
No, 8, 9, 10. But next week bench, is it conducive? Will the bench be able to take up your matters?
If your lordship sits next.
No, next week, at least I'm not there. My sister is also not there. But judgment by whom?
By,
Judgment by Justice Epe.
no,
Yes, judgment by Justice Epe.
correct. Single bench, my lord, and division bench by Justice,
The division bench was by Justice.
Surana.
Division bench. It's division bench only.
yes, my lord.
Yes, it went to Supreme Court, my lord, it has been remanded.
My lord,
Now, the single bench will not be able to take up the
Yes.
but
Yes.
we can take up
Yes,
the
any division.
any division bench,
any division, but except
Justice Surana and my lord.
No,
No, no, why I'm saying, my lord, single bench, my lord, it went in favor of the state government. Division bench we lost, and then we filed a SLP. My SLP, my lord, with some observation, again, matter was sent back.
Then I think those three judges.
Three judges, they cannot take up, my lord. I'm sorry, my lord.
Actually, it was not a case by division bench. Division bench had decided the matter on consensus. Now thereafter, they challenged the matter in the SLP, saying that our.
Okay, at least the honorable single judge can not there in the DP.
Yes.
And the next week, who's there?
Roster is come.
Justice Das is there, that I know.
Next week, my lord, roster is, my lord, it's not notified.
Okay, we'll check up if it's so, we fix up tentatively. Item number?
No,
Item number?
8 to 10.
8 to 10.
8 to 10, my lord.
State's appeal.
No, our.
No, they are appeal, my lord.
Sri Suraj Datta, Learned Senior Counsel, has prayed for some accommodation as there, am I saying some accommodation? Also heard Sri R.H. Nawam, Learned AAG for the state para on request, list on
Next week, my lord.
next Tuesday.
Next Tuesday.
Is a DB. Next Tuesday, okay.
Because it will be DB, Tuesday and Thursday are.
Okay, Tuesday with DB. If you
No,
find that
DB
the
on
DB is done, you can make a mention.
Yes.
Make it on Thursday because Tuesday there are 2-3 matters we have already.
Okay, Tuesday we already fix some matters, then Thursday.
11.
11th, huh? Thursday.
11/6.
Yes, please write, huh? Have your seat, please. The instant intra-court appeal has been preferred against a judgment dated 11/11/2025 passed in WPC so-and-so, whereby the writ petition has been allowed. Full stop. The present appellant is was the respondent number 7 in the said writ petition. Full stop. Tara. The case has a checkered history. Full stop. The issue has emanated from an NIT dated 10/12/2024 issued by the Deputy Commissioner Pake Sunsuha for carriage of PDS by land route, in which the present appellant bracket respondent number 7 and the present appellant and the writ petitioner had participated. Full stop. The evaluation was made on 10/1/2025 when the petitioner was selected and recommended. Full stop. The said recommendation was, however, the subject matter of challenge in WPC 95/25 filed by the writ petitioner. Full stop. In the meantime, on 12/2/2025, the approval in favor of the present appellant was granted. Full stop. Accordingly, on 28/7/2025, when WPC 95/2025 was listed, the Learned Senior Council had submitted that the cause of action had become infructuous. And accordingly, the writ petition was closed. Full stop. Thereafter, the instant writ petition was filed, being WPC 11125. Full stop. It also transpires that in the meantime, the work had no, don't say anything. Huh? We have heard Miss P. Borua, learned.
It's confusing. But I confusing.
Padmini Borua, learned counsel for the appellant. We have also heard Sri R.H. Navam, the learned AAG. Full stop. Miss Borua, the learned counsel for the appellant, has at the outset submitted that the writ petitioner did not have the locus to institute the challenge. Full stop. She has submitted that the writ petitioner was an unsuccessful bidder and accordingly could not have challenged the process in which her client was evaluated to be the suitable party. Full stop. She has submitted that this aspect has not been properly considered by the learned single judge. Full stop. She has also submitted that though various grounds of challenge were taken, the principal grounds was in the aspect of the bank guarantee and the earnest money deposit pertaining to her client. Full stop. It was the case of the writ petitioner that the bank guarantee was not from a nationalized bank in terms of the tender condition, but from the Apex or Arunachal
Pradesh Cooperative Apex Bank.
Arunachal Pradesh Cooperative Apex Bank. Full stop. As regards the earnest money deposit, she has clarified that though the deposit was not from the account of her client, but from one entity of which the chairman was what?
Lordship, the chairman of the cooperative society himself.
No, he was also chairman.
Lordship, this
Oh.
request.
Of another entity, the chairman of which was also the chairman
Of the-
of the respond number 7 cooperative society.
Lordship, appellant.
Of the appellant cooperative society. Full stop. She has submitted that in the evaluation conducted on 10/1/2025, all the relevant factors were taken into consideration. Full stop. Emphasis has been drawn to the note where there is a consideration on the numbers of godowns and vehicles. And it is submitted that on these relevant considerations, the recommendation in favor of her client was given. Full stop. She has submitted that though after the judgment dated 11/1/11/25, a new process was initiated, there is an order passed in the appeal not to finalize the same. Full stop. Para. The learned counsel for the appellant in support of her submission has relied upon the following judgments. Number 1, Poddar, I'll give the citation, 1991, 3 SCC, 273, Poddar, पूरा लिख लीजिए. Number 2, 2022, 6 SCC, 127, NG projects. Number 3, 2016, right 2016 before 2022, should be in chronology. 2016, 8 SCC, 622, Central Coal, full stop. The aforesaid cases have been cited primarily to impress upon the court that interpretation of the terms of the tender lies within the discretion of the tendering authorities, and the scope of judicial review is minimal. Full stop. She has also submitted that the respondent authorities had filed an affidavit in opposition wherein they have given the justification for recommending her client. Full stop. Para. 3, so far as the writ petitioner is concerned, which has been added as respondent number
Lordship, 7.
7 in this appeal is concerned, it is seen that in spite of service of notice, the writ petitioner has chosen not to contest the appeal. Full stop. In fact, there is an order dated 14/5/2026 passed by this court, wherein the service upon the private respondents, including the writ petitioner, has been held to be complete. 3, R.H. Nabam, the learned AAG, has submitted that the impugned decision was sought to be justified in the affidavit in opposition filed by the respondent number 4. Full stop. However, as a matter of fact, after passing of the judgment dated 11/11/2025, a new process has been initiated, which is almost complete. Full stop. He has also submitted that the new process has not been put to challenge, and therefore the embargo
That was postponed, my lord. 26.
Embargo put by this court on 26/5/2026 be removed, as there is urgency in the matter. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court, including the pleadings before the learned single judge, have been carefully perused. Full stop. Para. At the outset, we are reminded of the settled position of law that in matters of tenders, the discretion is to be has to be given. The discretion of the tendering authorities have to be given importance unless such discretion appears to have been exercised in an illegal and unreasonable manner. Full stop. Para. The initial recommendation dated 10/1/2025, as a matter of fact, was the subject matter of challenge in WBC 95 of 2025. Full stop. However, the said recommendation, the said writ petition was submitted to be infructuous, as in the meantime, the approval was granted on 12/2/2025. Full stop. Accordingly, the earlier writ petition WPC 95 of 2025 was closed as infructuous on the submission of the writ petitioner on 28/7/2025. Full stop. It has also been contended that by the learned counsel for the appellant that after such dismissal, the petitioner had started the work and was continuing. Full stop. Be that as it may, the subsequent writ petition WPC 111 of 25 was instituted challenging the grant of approval dated 12/2/2025. Full stop. Sarah? We have, however, noted that though in the evaluation dated 10/1/2025, the writ petitioner was held to be not eligible, such decision was not per se put to challenge in the present writ petition. Full stop. On the other hand, the petition has been instituted mainly challenging allotment of the work to the petitioner, to the appellant, in spite of the fact that the bid of the appellant had suffered from inherent defects. Full stop. Para. The learned single judge has considered the challenge, the aspect of locus, and has held that the petitioner had the locus. Full stop. Having gone through the discussion, we do not find that there is any scope of interference, or that there is any scope of taking a different view, and therefore the petition is held to be maintainable, as the petitioner had in fact participated in the bidding process and was not recommended wide the minutes of meeting dated 10/1/2025. Full stop. We have also taken note of the fact that the initial evaluation dated 10/1/2025 was indeed the subject matter of challenge in the first writ petition WPC 95 of 2025, which was, however, withdrawn as infructuous. Para. As regards the primary grounds of challenge, we have noted that the two grounds revolve around the bank guarantee and the EMD. Full stop. So far as the bank guarantee is concerned, there is a stipulation in the tender condition that such bank guarantee has to be from a nationalized bank. Full stop. The tender committee had, however, accepted the bank guarantee of the appellant, which was from the Arunachal Pradesh Cooperative Apex Bank, full stop. We are of the view that the discretion exercised by the tender committee, so far as the bank guarantee is concerned, may not be held to be so glaringly illegal, which would require an interference by in exercise of the powers of judicial review. Full stop. After all, the objective is to secure that the work is completed by the party. Full stop. There is, however, a different issue so far as the EMD is concerned. Full stop. The EMD has been deposited from the account of one HT Enterprise. Full stop. Para. The learned counsel for the appellant has strenuously argued that HT Enterprise is that the chairman of the HT Enterprise is also the chairman of the appellant. Full stop. Though the aforesaid averment may be correct as a matter of fact, comma, it is fact, comma, HT Enterprise is a different entity altogether. Full stop. The respondent number 4 in its affidavit filed on 26/2025 has dealt with the issue at page paragraph
2-1.
Page 212.
paragraph
Paragraph 8, my lord. Paragraph 8.
8.1.
Paragraph 8, page number 212 of the appeal memo.
In paragraph 8 within bracket 1, full stop. For the sake of clarity, the said averments are expected here and below. Page 212, 8 small 1. Huh? Though the settled law is that the tendering authorities should be left to exercise their discretion, comma, the discretion exercise so far as interpreting the EMD deposited in the name of another entity to be in consonance with clause 4.1 does not appear to be reasonable at all, full stop. The same would lead to an absurd situation wherein any other entity would deposit the EMD, leading, which would open a floodgate wherein there would be benami, wherein work should be done in the name of somebody else, which is not the purpose of the present scheme. Full stop. The scheme is mainly for cooperative societies, and both the appellant and the respondent number 7 are in fact cooperative societies. Full stop. The interference by the Honorable Single Judge on this aspect is found in paragraph so and so of the judgment, which reads as follows. You page
Paragraph 28.
28.
28.
There are 246. Oh, page 246.
Paragraph 28, page 246. Please put this noting. But we are of the opinion that the conclusion reached by the learned single judge on this aspect is in the right direction, and we concur with the same. Full stop. Para, in view of the above, comma, we do not find the present appeal, present case to be a fit, present appeal. No, we do not find the present case to be a fit case for interference. Full stop. In any case, comma, the scope of interference in an intra-court appeal is limited. Full stop. The Honorable Supreme Court, in the case of management of Narendra T, I'll give you, has laid down as follows. Para. We quote it, huh? In view of the above, the writ appeal stands dismissed. Full stop. the embargo put by this court in the order dated 26/5/2026 is removed, and the respondent authorities would be at liberty to go ahead and finalize the new tender process in accordance with law.
Deeply obliged.
Lordship,
Sorry, Madam, you argued well, but. we could not help.
Lordship, can we participate, Lordship, if that liberty is given, Lordship?
After
It's,
Only for pendency of this appeal, Lordship, we did not
done,
participate.
how to participate now?
Deeply obliged, my lord.
Item number 4.
Lordship, in this matter, rule is under challenge, Lordship. Learned AG is appearing for the state. So we have consented if it can be fixed on 21st of July, Lordship. That's immediately after reopening of the vacations.
Mr. Sakya, you are the petitioner.
Petitioner, Lordship.
Okay, and
I'm for my lord 5, 6, 7, and 8.
you are the beneficiary of the rules.
Lordship.
Heard 3, R. Sakya, Learned Senior Counsel, assisted by who is assisting you?
Ivan.
IBAM for the petitioner. Also heard Priya Stapin, the Learned Senior Advocate, as well as Sri S.K. Deuri, Learned Counsel for the private respondents.
Yes, ma'am.
Para? Sri Tapin, the Learned Senior Advocate, has informed that since certain rules, since the vagaries of certain rules are put to question, comma, the Learned AG would appear on behalf of the state, and therefore he prays for some accommodation. Para? As agreed to by the Learned Counsel for the parties, comma, matter is adjourned to be listed on 21st of July. For admission hearing.
Yes.
Close.
Admission.
Item number 5 and 6.
Five and 6 states appeal.
Lordship. State appeal, Lordship.
It was heard at length
Lordship.
by whom? Okay,
Nelson.
doesn't matter. Today is for disposal.
About disposal, Lordship. The parties are ready, Lordship.
Okay.
Lordship, basically, Lordship, in public context, Lordship, in contract work, Lordship, tender is the law, Lordship. But the Learned Single Bench has gone against that law without carving out, Lordship, any exception as may be permissible under the law, Lordship. So that's the, before coming to the impugn order, Lordship, I'd like to take Lordship to the background of the case, Lordship. Lordship, background is in 3 parts, Lordship. Firstly, Lordship, this particular road, this is a construction issue, Lordship.
Construction of a road.
Road from Itanagar to Jote is about 20 kilometers, Lordship. The issue is revolving around this particular stage of the road, Lordship. Lordship, the first part is, if Lordship come to page 99, Lordship.
99.
99, Lordship. This particular work, Lordship, this is the agreement between the government and the present respondent, who is the writ petitioner. Here,
The writ petition was selected.
lawsuit, in this particular lawsuit, work lawsuit, that is for the lawsuit widening and strengthening this particular road lawsuit.
No, the petitioner was selected.
Selected lawsuit.
Now,
He had completed that work also lawsuit. Now fact is something different lawsuit. I'm coming to that lawsuit.
so this was an existing work which where the petitioner was involved.
Yes, lawsuit. He was even awarded and he had completed this work also lawsuit.
He was completed.
Yes, lawsuit. And this particular work is for lawsuit widening and strengthening of this particular road lawsuit. This is agreement dated 10 November 2021 lawsuit. And the work was completed on 31st 2024.
Agreement 31st.
The agreement is dated
10/11/21.
2021,
Completed.
and the work was completed on 31st March 2024.
Work completed.
Completed lawsuit.
Yes.
Now that chapter lawsuit closed lawsuit. That chapter closed lawsuit. Now kindly come to page 104. After 4 months lawsuit, after completions of that particular work, after 4 months, this is the DO letter lawsuit, not issued by Honorable MLA of lawsuit that Duimukh constituency. Here, lawsuit request has been made to advisor to the Honorable advisor to PW. Sorry, this is purpose hearing Honorable advisor to PW Minister lawsuit. By this lawsuit, DO note lawsuit, request has been made. 6 numbers of bridges lawsuit over this very stretch of road lawsuit, that in the same stretch of road lawsuit. This because these roads are bridges are in dilapidated condition lawsuit. So Honorable MLA has made request to the lawsuit this particular authority. If these bridges can be constructed by the existing contractor, that is a writ petitioner lawsuit. Now the second chapter is started lawsuit. Then kindly come to page 106 lawsuit. This particular DO note was further process lawsuit. And here lawsuit Superintendent Engineer PW Capital Circle has written to so and so, and referring the request made by the Honorable MLA Duimukh. Then it was again further process. At page 107 lawsuit.
What is 106? 31 July?
31 July 2024 lawsuit.
What is this letter?
Here lawsuit the letter of the Honorable MLA has been forwarded lawsuit.
Okay.
And it says lawsuit. I would like to read the operation
SC
first.
to the executive, no. Why should the SC write to the superintendent engineer, executive engineer?
Lawsuit to here lawsuit. The suggestions put forward by the Honorable MLA appears to be appreciable in view.
Intra-office communication regarding the proposal of the MLA.
Yes, that's. Then lawsuit kindly come to page 107 lawsuit. It was processed further and giving citations some because if press tender is lawsuit floated for these bridges, then it is time taking and all lawsuit citing all those things lawsuit. It was this note was issued. Then ultimately what happened lawsuit? Kindly come to 113 lawsuit page. It went up to Honorable CM lawsuit. At page 113, lawsuit will, down below lawsuit will find the Honorable CM. He has just put his signature, seems as a mark of approval lawsuit. On bottom lawsuit.
He approved that the work of construction of bridges should be taken up.
Bridges by the present petitioner lawsuit. Basing on this approval, Lordship, further Lordship, it was processed, and then kindly come to page Lordship 120. This is the communications made by the executive engineer to the present petitioner, read petitioner, the present respondent, Lordship. Lordship, this is letter dated 23rd September 2024. Widening is changing of so and so 20 kilometer, the additional work, Lordship.
120.
Additional work for
The 6 numbers of bridges, Lordship. Bridges, Lordship. Now 6 numbers of bridges are here. It's only
Mr. Dasgupta, your name is Bhimji Velji.
Bhimji Belji. By this letter, Lordship, the Bhimji Belji, that's a read petition has been requested to Lordship carry out subsoil investigations over the 6 bridges, Lordship. And to submit the Lordship, the report before the authority.
Yes.
Here, Lordship, just I like to just inform this Honorable Court, Lordship. This is a stage, Lordship. This prior to preparation of DPR, Lordship. For this particular work, even Lordship, it can be engaged to any expert, Lordship. So for this subsoil testing is concerned, Lordship. It is basically done by the expert, and for this particular exercise, Lordship, even fund can be allocated by the authority, government, Lordship. As I'm repeating, Lordship, this is prior to preparation of DPR, Lordship. And here, Lordship, just below the column, Lordship, just I like to. SSI reports along with structural design and drawings duly vetted from any NIT, public IIT, along with item-wise BOQ should be submitted to each bridge in triplicate for further action. Nomenclature of items shall be conformity with the specific as per mode. Payment for SSI, design oblique drawings shall be made upon sanction and fund allocation from the government. The report should be submitted within 3 months and no extension is permitted, being urgent nature of work. You are also requested to keep the existing bridges operational by carrying out necessary repair oblique maintenance as and when required duly certified the field engineer. The work shall be taken up as additional work under the existing agreement subject to approval of BOQ and technical sanction. It will be subject to Lordship. That is, Lordship, after submissions of the soil testing and all, then DPI will be prepared, then tender has to be plotted, then award has to be, then construction has to be. That is the sequence, Lordship. Then, Lordship, kindly come to next page, that is page 122, Lordship. Page 122. Basing on this letter, Lordship, since the read petitioner has submitted the Lordship, that soil testing report to the authority. Here, this is the one communications which is very pertinent for the issue before this court, Lordship, in present case. This is communications made by the assistant engineer, Balijan subdivision to the read petitioner. That's the Bhimji Belji, the present respondent, Lordship. Just I'd like to read this communication.
Yes, please.
As undersigned is aware of the fact that you have already started groundwork preparations for constructions of bridges in the said road, while assuring coordination and cooperation from this, and you are requested to kindly dismantle a bridge carefully, avoiding any kind of accident and major damages to bridge parts, and all the dismantled parts may kindly be handed over to the concerned junior engineer for proper office record. Out of 6 bridges, 6 numbers bridges, your good self may start with those bridges which are free from any encumbrance by providing proper conveyance to the traffic. In the meantime, this office shall pursue a non-encumbrance of other bridges. And also, it may kindly be noted that traffic flow must not be compromised. This is the communications by the assistant engineer to the read petitioner. Here, Lordship, just I'd like to point one thing. By this particular letter, Lordship, it's not exactly directed to start the work, Lordship. But here what it says, as undersigned is aware of the fact that you have already started groundwork, preparations for construction of bridges and all, Lordship. Here, Lordship, just I would like to make a submission, Lordship. There is no such award of the work to the writ petitioner, Lordship, till this particular communication, Lordship. And this communication also is by the assistant engineer. So there is no the duly awarding of the work, Lordship. Award has to be made in the name of the governor of the state. And that is to be done as per the Lordship, law, Lordship. Now, kindly come to page 236, Lordship. 236. Lordship, case is there, Lordship, there is no such award of the work to the writ petitioner. But since on understanding, Lordship, the writ petitioner has already started the work. So that is the seems, Lordship, fact of the case, Lordship. Here, Lordship, by letter dated 21/1/2025, this is written by the Lordship Chief Engineer to the Executive Engineer concerned, Lordship. Here, Lordship, unauthorized construction activities in Itanagar Jyoti Road and sanctioned under so and so. Here, Lordship, relevant is at next page. Here, our direction is given to stop the work, Lordship, because there's no such award and even it's not sanctioned also, Lordship. This is a letter dated 21/1/2025, Lordship. Then second letter is at page 238, Lordship. This is the same, Lordship, reminder, Lordship. Here also, Lordship, this is by Chief Engineer to Executive Engineer. Page 238, Lordship. Annexure written 3, Lordship. May I read just operating line, Lordship? Citing all and all, Lordship, the facts of, Lordship, construction without the proper award, Lordship. You are directed to stop any unauthorized work other than the one at Dokuso Nala, as there is no government approval yet. The Chief Engineers so and so and PW division have no authority to override Corel formalities and award work beyond their competency. The above order is flagrant violations of the government norm and CPW so and so, Lordship. Now, here, Lordship, the second chapter, Lordship, close here, Lordship. Now, kindly come to page 47, Lordship. The third parts of the Lordship, the background is it starts from this page 47, Lordship. Lordship, for the purpose of, Lordship, the administrative approval of any work, Lordship, and here there's a delegations of financial power, Lordship. And this page 47 is the, Lordship, office memorandum on finance delegations of the financial power for works, Lordship. Lordship will find serial number 1 to 5 is here, Lordship. Who are the authorities who have been delegated with the financial power, Lordship, to give administrative approval, Lordship. The present work, that is the additional work, Lordship, that is the construction of bridges, it's for 80 crore. Whereas the Lordship, the earlier, Lordship, the existing work, which was completed, that is for 60 crore, Lordship.
Okay.
Now, Lordship will find at serial number 5, Lordship, who is the competent authority to, Lordship, accord administrative approval for the amount of the work which is more than Lordship,
100 crore.
1 crore.
1 crore.
1 crore.
1 crore.
1 crore, Lordship. This is Cabinet Subcommittee, Lordship, comprising of Honorable CM, Honorable Minister Finance, and Honorable Minister in charge, Lordship. Honorable Chief Minister, Finance Minister, and the concerned Lordship, Minister, Lordship. They forms the Lordship Cabinet Subcommittee, Lordship. In the present case, Lordship, after Lordship preparations of DPR and all, Lordship, now approval has to be done by this committee, Lordship. And CM, Lordship, he alone, Lordship, that which he has put signed, Lordship. That is not the approval for this particular, means legally it's not, Lordship, permissible, Lordship, as per this delegations of the finance power, Lordship. Now, kindly come to page 48, Lordship. Now, approval before the Lordship, the Cabinet Subcommittee is started from page 48, Lordship. This, after preparations of DPR and all, Lordship, this project, Lordship, it was placed before the Cabinet Subcommittee, Lordship. Page 48. Relevant is it page 50, Lordship, 50. Just I'd like to read this approval, Lordship. An administrative approval to the tune of rupees 80 crore 50 lakhs has been obtained from the Cabinet Subcommittee in a one go by file number so and so, and for which a copy of administrative approval accorded from CSC, this is the Cabinet Subcommittee, is attached in the file number so and so and so and so and so. Hence, proposal may put forward directly to FD, means Finance Department, for accord of finance concurrence to the tune of rupees so and so, with an expenditure restricted to rupees so and so lakh during so and so, as per fund provision kept under Department additional so and so and so. Here, Lordship, this particular project has been approved by Cabinet Subcommittee. Then it has been forwarded to the Finance Department for their, Lordship, concurrence, Lordship. Then kindly come to page 57, Lordship. Page 57, Lordship. This is a Lordship, finance concurrence given by the Finance Department. Here on the, Lordship, following terms and conditions, Lordship. And I'm taking, Lordship, to the condition number 12, which is relevant.
Item number?
Page, condition number 12, Lordship. Next page, Lordship. May I read, Lordship? 10 also is relevant, but on the same footing, Lordship.
Yes.
12, Lordship. 10 and 12, both are, Lordship, on the same footing. The education to the works, scheme, projects, and the procurement of items, materials, furniture, etc. should be done strictly as per provisions of GFR, DAPR, CPW manual, etc. All the financial rules and regulations, the guidelines and directive issued by Government of India, Ministry of Finance, Government of India, Administrative Ministry of Government of India, CBC, and Government of Arunachal Pradesh in this regard from time to time should be followed in letter and spirit without fail. The process of tendering, it may be noted, Lordship, and competitive bidding should mandatorily be followed and complied with as envisaged in the GFR, this is General Finance Rule, DAPR, financial rules and regulation and the conditions of guidelines, circulars, and the directive issued prescribed by Government of India, CBC, and so and so. So here, Lordship, the concurrence given by the Finance Department, the condition has been put, you have to go for tender, Lordship, while executing this particular sanction works. So that's 6 number of previous Lordship. Then Lordship, kindly come to page Lordship 197. After it has been, Lordship, concurrence has been given by the Finance Department. Lordship, it has been, Lordship, then sent back to the concerned department, that is Public Works Department, Lordship. And Public Works Department, Lordship, after obtaining the administrative approval and finance concurrence, then issued this sanction order, 197, Lordship, dated 11 March 2025, signed on 18/3/2025, Lordship. Here, Lordship will note that serial number, condition number 12, Lordship. This is a sanction order, Lordship. Condition number 12, Lordship. The execution of work scheme of pressure and procurement of so and furniture, etc., should be done strictly as per provisions of GFR, DFR, Civil Manual, etc. All the financial rules and regulation, the guidelines and directive issued by the Government of India, Mr. So and so, and Government of so and so and so, etc. Or natural in this regard from time should be followed in letter and spirit without fail. The work shall be carried out through extended tender. Extended tender. To my understanding, Lordship, extended tender itself is, Lordship, stranger to the Lordship, the contract, Lordship, contract law, Lordship. That's my understanding, Lordship. But this is my action, Lordship. Done by through extended tender as per approval of government by noted 530 dated 17/9/2024.
Yes.
This Lordship by note 530, this is 530 dated 17/9/2024 is concerned, Lordship. This is the Lordship, the earlier Honorable Chief Minister's approval, Lordship, which is prior to Lordship soil testing, Lordship. Not in terms of the Lordship, the concurrence given by the Finance Department.
Page 113 is 17/9/2024.
Page
113.
113.
Yes.
Yes, Lordship.
Yes.
This is dated 17/9/2024.
Type copy is there.
This is Lordship.
Type copy is at 114.
Type copy is here, Lordship. Here, Lordship, while issuing the sanction order, Lordship, this modification has been done in condition number 12. Here, Lordship, instead of referring the approval given by the finance department, that is to go for the tender, rather, Lordship, the approval given by the Honorable CM, which is prior to soil testing, has been quoted, Lordship. That modification came into, Lordship. Then, Lordship, kindly come to page Lordship 61, Lordship.
61.
61. It's relevant to the Lordship, this very sanction order, Lordship. This is the part of the Lordship, this office noting, Lordship. how Lordship that sanction order has been issued, Lordship.
Yes.
Lordship will find note 48, Lordship. Note 48.
Yes.
Joint Secretary and Deputy Secretary may both personally see if the DSO, this DSO means draft sanction order, is as per finance concurrence, and then issue it after ensuring the same. This is by the Principal Secretary, PW Department, Lordship. Here, Lordship, instruction has been given to Joint Secretary and Deputy Secretary to issue sanction order as per the condition given by the Finance Department, Lordship. Then kindly come to next page, Lordship. Lordship, as I've submitted, Lordship, page 197, Lordship, the sanction order is not as per the, in terms of the Lordship, finance concurrence given by the Finance Department, Lordship. Therefore, Lordship, next page, that is page 62, Lordship. These anomalies was, Lordship, came to notice of the Lordship authority, Lordship. Then this, Lordship, kindly see note 51, Lordship. Compare the DSO with finance concurrence as given at serial numbers, not number so and so, as directed by authority. This is also with me. The ever so and so enter in the place of so and so, as per so and so. So the second sentence, the serial number 12 of the finance concurrence relating to mandatory tendering and commission is also not mentioned. Instead, a different sentence is added. Further details like code number, major head, sub major head, etc. are also not mentioned in the DSO. Please issue order as per the concurrence to avoid so and so and so. This is on very immediately after Lordship, 2 days Lordship. Other sanction. This is dated 17/3/2025 Lordship. Note. Within a Lordship short period, 1-2 days, Lordship, these anomalies have been Lordship detected, and then press sanction order has been issued. Press sanction order has been issued, and prior to that, Lordship, corrigendum has been issued at page 199. Corrigendum has been issued at page 199. Then press tender sanction order has been issued at page 200. Then page 200, Lordship, 200. This is the sanction order. It was issued on 21, Lordship. After 2 days, it happened within a week only, Lordship. All this. This is the final sanction order, and Lordship will find a serial number, condition number 12. Here, tendering and competitive bidding has been inserted, Lordship, as per the director of directions of the Lordship Principal Secretary, which is in consonance with the Lordship conditions provided by the Finance Department.
129.
Then Lordship, kindly come to, this is the Lordship, the facts, and then kindly come to page 144 Lordship. As per the Lordship, the press sanction order, tender has to be Lordship plotted.
144.
144 Lordship. This is the Lordship impugn order in the writ petition. After Lordship, it has been sanctioned by the department Lordship. This letter was issued by the executive engineer, Vimuk division, to the writ petitioner Lordship. Now, what decision has been taken here, Lordship? This is the impugn order, Lordship, before the single bench.
29-3.
29/3/2025, Lordship.
What has been stated here?
Here, Lordship, I just allow to read, Lordship. It has been further decided to implement the project during the meeting chaired by Chief Engineer on so and so, segregating in two parts as under. Bridge over Dokoso/Gera Nala as extended portions of the agreement so and so and so for regulation being already executed /nearing completions and remaining 4 bridges by plotting press tender Lordship. Here, Lordship, so far this Gera Nala and Dokoso, these 2 bridges are concerned. Petitioner was already executing the work, Lordship, without Lordship the award. And almost nearly Lordship completions or Lordship. At that stage, this decision has been taken. So far these 2 bridges are concerned, then let the petitioner be complete the works, Lordship. But for the rest 4 bridges, Lordship, tender will be plotted. That is the Lordship communications made by the executive engineer to the writ petitioner. And this has been challenged.
Yes.
Lordship, now I have Lordship on earlier occasion, Lordship, I place a bunch of papers, Lordship, where general financial rule.
Okay, there are some papers. Yes, executive business.
Yes, here Lordship, executive business also is there, Lordship. Apart from Lordship will find this general financial rules, Lordship. Chapter 5.
It was in my device, last of all division. General financial rules.
Yes, Lord.
Yes.
Lordship, I've even done the pagination also. The first page, Lordship. Lordship will find the rule 130 on past, Lordship.
130 of financial.
Original works, Lordship. What is original works, Lordship? Original works means all new constructions, site preparations, addition and alteration to existing work, special repairs to newly purchased or previously abandoned building or structure, including remodeling or replacement. Minor works means works which add capital value to existing assets but do not.
What has the learned single judge held?
Yes.
Lordship, learned single judge, Lordship, just set aside this particular communication. And reason has not been given, Lordship.
Yes.
And the stand taken by us in our affidavit, that has not been answered, Lordship, has not been considered. We have stated all these things, Lordship. This
You're in short, your case is that these are entirely new works.
New works.
But since 2 works they have already started,
Correct.
you have kept it apart from the purview of new tender to be floated and allowed them to proceed so far as Dokoso and Geranala is concerned. So far the four other bridges are concerned, you had decided to go for a fresh tender, which is the subject matter of challenge by the petitioner. They are contending that since initially the CM had approved, it had gone to the highest authority of the executive, and approval is there. Therefore, this decision to go for a fresh tender, so far as four bridges are concerned, would not be permitted in law.
Yes.
And your contention is that approval of the CM was confined only to the aspect of soil testing and the initial works even before the DPR could be prepared. And the aspect of floating of tenders would come after the project is submitted, DPR is submitted, and all other formalities are over.
Correct.
And without that, tender work cannot be allotted. And in that line, the impugned notice of 29/3/2025 was issued. That is your case.
Yeah. Or that part is simultaneous lawsuit. As per the delegations of financial lawsuit that power, the cabinet subcommittee is the authority which has to approve lawsuit.
Chief Minister and Minister the DPR to the
The earlier lawsuit, the chief CM lawsuit, he has made approval, but that is lawsuit not as per the delegations of financial lawsuit.
The CM's approval, as per your submission, is to be confined to the aspect of soil testing.
Lawsuit, no. Earlier lawsuit, as per MLS, not lawsuit. That you law. Here lawsuit.
MLA's recommendation cannot be sacrosanct. MLA can recommend that this person has done this road. So why don't you get the 6 bridges also done through him? That will not give any right to the petitioner per se.
Yes.
He's not claiming any right from that, but the process started from that letter. And therefore, a soil conservation, soil testing was done, which was incidentally done by the same contractor because he was doing the work.
Yes.
You said that by engaging the contractor for soil testing will not give him a right.
Yes.
Only even for the works to be done by them, because soil testing can be done by any third party.
Actually, that soil testing was permitted to be done by the petitioner. That was after the approval of the Honorable CM only.
Now, suppose worst case, we do not agree with you. We might, if we take a view that yes, the process has not met all the formalities in letter and spirit, but fact remains that he has done the work of the road, and instead of doing the bridges in between through somebody else, get it done through him. But what would be the rate? How would you assess? How do you come to the rate on which the work would be done?
80 crores.
Therefore, that to that stage has not yet come, because even if NIT is floated, then only we can.
That is exactly what we would like to have. Suppose for the time being we do not agree with you. Let the work be done by him. But who would assess the rate? What would be a fair rate? How do you arrive at a fair rate without there being any competition? Not my point. If you say that you do the work, he might, assuming, just argument's sake, he gives an exorbitant rate. Will you do that? Will not do that. So why is the requirement for tender? To have a competition amongst the eligible bidders, so that you get a competitive rate, which is in the interest of the state. Now, here's only a situation with one bidder. So what would be the rate?
That part,
worst case scenario.
That part is silenced in the present case, because there is no
Rate has been estimated by 80 crores. Rate has been estimated
By
80 crores
by whom?
by the government builder in the sanctioning letter.
Subsequently, DPR has been prepared.
Yes, that has been in place.
But 80 crore would be the estimated rate.
Yes, and I have to complete this work by 80 crores.
And if there is a competition, somebody might say that
It may be 100 crores, 200 crores.
it may be 75 crore.
It may be 75 crores, it may be 80 crores.
But from the papers, it does not appear that formalities have been fulfilled letter and spirit. But with that one view may be taken that is a very technical kind of a submission.
Yes.
So how do you balance it?
Here, Lordship,
Page 113.
State has come upon appeal.
Hmm.
Since it's a state appeal, obviously they have construed themselves that the initial approval by the Honorable CM was not for the entire work. It was only for the initial work of soil testing.
That is not the case.
it is understood this for inter works
Page number 113.
because for these six bridges, Lordship, the proposal was processed, Lordship. But my case is, Lordship, even if it's approved by the Honorable CM, Lordship, now what happened? Now, Lordship, soil testing, then DPR has to be prepared, then DPR has to be, Lordship, sanctioned by the government again, then tender has to be plotted, Lordship. That stage is yet to come, Lordship. And here, what happened, Lordship? The petitioner, Lordship, started the work, Lordship. Seems on understanding with the Lordship authority, but there is no such communications directing them to the work to start the work, Lordship. Now, authority realized that, Lordship, so far the works which they are carrying out, Lordship, 2 bridges, Lordship, let him complete, Lordship. And in terms of this impugn letter, even agreement has been signed for 2 bridges with the petition, Lordship. And it's almost verge of completion, or is now latest status I don't have, but almost completed, Lordship. And so far 6 bridges are 4 bridges are concerned, Lordship. We want to go for as per the law, Lordship. That's our case, Lordship. Now, even after, Lordship, setting aside this, Lordship, the letter communication, now what will be the consequences, Lordship? Because petitioner has not been awarded to carry out the works so far all the 6 bridges are concerned, Lordship. What will be consequential order also is not there, Lordship. Just simply set aside this communication, Lordship. Consequential order has to be there, Lordship.
Can we go through the impugned judgment?
Lordship. And just actually, before coming to that, just I wanted to apprise this for Lordship. As per this general financial rules, Lordship, what is the original works? What is the, Lordship, additional work, Lordship? These 6 bridges, it's a purely, Lordship, original works, Lordship, for which the constructions of which, Lordship, the tender has to be plotted or the rules has to be followed, Lordship. Lordship, the impugn order, it starts from, Lordship, page
29.
25, Lordship.
Yes, sir.
Page 25.
A part of portion is from page 29.
Why 2 repetitions?
There are 2 communications directing them to stop the works, Lordship. As I, Lordship, earlier, Lordship, I pointed out, Lordship. There are 2 communications of January and February that have been SL in another writ petition, Lordship. Petitioner, Lordship, even directed to stop the works, Lordship. Lordship, page 45. It starts from page 25. Page 45, the paragraph 26, Lordship.
Page 45.
45. Although
So they had cited, they had relied upon the principles of promissory estoppel before
They-
the honorable single judge.
that exactly that also has not been.
Because Motilal Padampat and all those have been cited. We have read in the judgment.
That is.
But your contention probably would be that there cannot be estoppel in law.
Against the law, it's not.
Because law requires work to be done through a certain process.
Yes.
And unless that process is fulfilled, petitioner cannot claim.
No, sir.
And in spite of that, for two works which they have already gone ahead, you are not touching those two works.
Okay.
Only the other four works
No.
you want to do through the prescribed procedure.
Correct.
So what is there in page 45?
45 lordship here. Paragraph 26 lordship. Although the learned additional advocate general has sought to impress upon the court that the cabinet approval was required to be taken for allotment of said work, but the fact remains that approval of honorable CM has been taken after file was routed through the department and administrative head of the department and advisor so and so. Further, the order dated so and so, by which administrative approval and administrative sanction was given by the governor before the corrigendum or even after a corrigendum is with the concurrence of the finance department. Such being the position, the allotment of the works to the petitioner firm cannot be termed to be irregular or illegal for that matter. On contrary, in view of the rules so and so, Arunachal Pradesh rules of executive business, read with clause so and so of the schedule to the said rules, proposal to vary or reverse the decisions taken earlier will have to be placed before the cabinet. I therefore find force in the argument made by the senior counsel for the petition, and therefore, upon due consideration of the case in its entirety, the impugned communications are found to be not sustainable and are accordingly set aside. The interim so and so and so and so. Here, lordship, being the position, the allotment of work to the petitioner firm cannot be termed as irregular. There's no allotment as such, lordship. And in our affidavit in opposition lordship, we taken a categorical stand in paragraph 3 that there is no provision for extended tender. And as per the GFR lordship, tender has to be plotted. And this particular work lordship, 6 number of bridges, it forms original works lordship. It's nothing to do with that earlier works lordship. So we have to go for tender as per the law. That's our stand in the lordship, the affidavit, and that has not been discussed and even not answered in the impugned judgment lordship. And lordship, committee cannot be lordship identified with the honorable CM lordship, because committee is a one entity lordship, and the capacity of honorable CM is different lordship.
Subcommittee.
Sorry, subcommittee.
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 Not committee, subcommittee.
Subcommittee. Thank you. As per the finance delegation power lordship, that office memorandum, subcommittee is the authority who has to lordship. And now, learn a single bench lordship. What held lordship? Once lordship decision has been lordship, if any correction, even if it's to be made lordship, that has to be done by the subcommittee lordship. That's the conclusion lordship. Here lordship, the error started only in the department lordship, while issuing the sanction order lordship. Because cabinet lordship subcommittee, that has not lordship approved for lordship work to be done by the petitioner lordship. Cabinet subcommittee. And finance concurrence also has been given on the condition that lordship, the work will be awarded by tender lordship. So therefore, those part lordship, there's no error Error started only when it went to the department, it's the PW department. And while issuing the past sanction order, something has crept into, which was not the part of the finance concurrence law. And even if that is to be corrected, no need to go for the finance cabinet again, lawsuit. Because yes, no, we are not going to lawsuit modify the terms and conditions of the cabinet or the finance department. Rather, we are correcting it so that it's consonance with the finance department. Then kindly take up this lawsuit, extract
Which one?
just general financial rules lawsuit. I have already read lawsuit rule 30, 130, and then kindly come to rule 132 lawsuit. Power to sanction works lawsuit. The powers delegated to the various subordinate authorities to accord administrative approval, sanction expenditure, and reappropriate funds for works are regulated by the delegations of financial power rules and other orders contained in the respective department regulations and so. As per this lawsuit, those who have been delegated with the power lawsuit, they are the authority lawsuit. Then kindly come to the bottom 136, rule 136 lawsuit. 136, rule 136 says lawsuit, no work shall be commenced or liability incur in the connection with it until administrative approval has been obtained from the appropriate authority in each case. The sanction to incur expense has been obtained from the competent authority. A properly detailed design has been sanctioned while designing the project, etc. Principle of so and so and so. So some condition has been given laws. Without lawsuit sanction, the work cannot be awarded. Then kindly
We will come back.
So far law is concerned, that's Nagar Nigam Meerut lawsuit. It's 2006-13 SCC.
Which one?
This Nagar Nigam Meerut versus Al Fahim Meat Exports lawsuit. 2006-13 SCC.
Just a minute.
List of this way.
That citation I have not placed, but list I have given. List.
You can cite it.
Paragraph lawsuit 13 to 19.
No, what is the citation?
This is 2006-13 SCC.
2006.
13 SCC. 382. 382.
13 SCC. 382.
Paragraph
Name?
13. This is Nagar Nigam.
আমার মনে আছে ছিল
Nagar Nigam. Paragraph.
Paragraph 13 to 19.
ছিল
2006-13 SCC. And basing on this very citation lawsuit, central.
Yes, I've got it.
Basing on that, Lordship, even central CBC has Lordship issued guidelines. That is Lordship, that bunch of papers is there, Lordship. JFR, where the JFR is, yeah, Lordship will find the extract of JFR.
This extract is.
Yeah, Lordship, page, I have done the pagination, page 4, Lordship.
Of the GFR.
Yes.
Page 4. GFR.
Here, Lordship, this very citation, page 4. And page 6 also. CBC guidelines. These are the two laws, Lordship, specifically where it says, Lordship, the public works has to be awarded through tender, Lordship. So, definitely, so Lordship, there are some deviations on my part also, Lordship. But when now I want to correct myself, Lordship, the deviation cannot be endorsed by this honor court, Lordship.
Which has been into integrity system.
Yep, 13 to 19.
13.
1, 3. 13. And earlier I forgot to refer one, that's rule 139 of GFR, Lordship. It is at page 2. Rule 139, the clause 3, 4, and 6, Lordship. Where it says, Lordship, tender has to be, Lordship, floated.
This has sub-rule 4. Open tenders will be called for works costing 5 to 30 lakhs. What about more?
This, Lordship, here is applicable for those also, Lordship. I think
No.
Here, particular, here, Lordship, this is up to 2017. I think.
No, in 17, there were no works more than 30 lakhs.
It's up to 30 lakhs, Lordship. Correct, Lordship.
There is some other.
It's 30 lakhs, Lordship. That apart, Lordship, so far this financial delegations of financial power is concerned, Lordship. That even, Lordship, in impugned judgment also, there was submission from our part, Lordship. The approving authority is the cabinet subcommittee, Lordship. Even that has been recorded. But all those are staying, Lordship. JPR and all, Lordship. That has not been, Lordship, addressed by the learned single bench, Lordship. That is there, Lordship. So that's all, Lordship.
Yes, Mr. Arshid.
Make your lordship.
Yes.
Blood, here what my learned friend argued is that whenever in work, whose work is more than one course, that should be approved by the subcommittee. That is their case, Milord. And subcabinet committee. Cabinet committee consists of 3 persons.
Yes.
They are number 1, Chief Minister. Second, Milord, Finance Minister. And third, Milord, the Minister concerned of the department.
Yes.
Now, Milord, this is a matter pertains to PWD.
Yes.
Now, here, Milord, one thing that has to be considered by your lordship, that the PWD minister and the chief minister are the same person. Now, Milord, chief minister, well, your lordship, please come to page number 113. There is not very legible, Milord. Your lordship may kindly consider page 114, which is a type copy, Milord. Now, your lordship, Milord, paragraph 9. Sorry, paragraph, page 114. Let me read this file constituted in this behalf. The proposal for this replacement of dilapidated single line bridges to double line bridges, 70 are such and such, confirming the highway specification recommended by Chief Engineer PWD Oregon, has been examined with the finding as under. The project upgradation of Itanagar Jote Road to the state highway under Papanpure district was conceived during the year 2020 under such and such. Original project cost was of rupees 153.97 crores, however, could not be considered at one go, thereby delinking the bridge components from the scope, and accordingly rupees 89.52 crores was sanctioned under such and such. That was planned. It is reported that all the existing 6 bridges are no longer considered safe, having outlived lifespan and require immediate replacement, retrofitting measures to avoid any accident, collapse during plying or traffic and other heavy vehicles in this road. Due to importance of this highway from the strategic point as well as all weather connectivity aspect to prestigious national institute like NIT, FIT, etc., the proposal can be tagged within the ambit of the works of inescapable nature. given in para 1.5 of CPWD work manual. That is a work manual where this provision is contained. This office has already taken up the matter with the Director Planning Government of Arunachal Pradesh, earmarked rupees 80.49 crores for conversion of the existing structure to S70R loading bridges, being is inescapable component of being inseparable component of single project. The balance work can be taken up through the same agency as suggested by Honorable MLA and accompanied by CE Western, recommended by CE Western. As per the feedbacks of the documents furnished by Executive Engineer Doimuk, contractor Messrs. We are Millard Private Limited, a Gujarat-based firm, has executed 2 highway projects in the state of Arunachal Pradesh, having both road as well as the major bridges, totaling 5 number of such and such EPC mode referred below. They have already executed this thing. Lord. The credential of the firm as established from the above indicates about the financial as well as the technical capability for undertaking the bridge works and recommended by Chief Engineer Western. The methodology and terms of procurement can be considered as an additional work. Additional work by executing the agreement as already applied to earlier similar to such and such. Now, look, this was the suggestion, Milord. And now if you should come to page 113, at the left hand Milord, EU number 530. You got it?
Yes.
EU number 530 dated 17/9/2024, CM Office, Arunachal Pradesh, Itanagar. He had approved it. So far, CPWD manual is concerned, but I am passing it. General condition of contact. General condition of contact. Clause 12.
We have one of this. We have.
The CPWD manual is with us. You can provide your lordship.
You can make a copy of this. You can do one thing. You have a photocopy here. Copy is there?
No, I can pass it.
No, we'll have a copy. Get a SLM.
No. Class 12. Ada poin ni. Ada kau kau satu beli mana kau satu? Sebelum beli mana je? Mana? Amader juga আমরা দিলাম এই মাত্র। Oh yeah. No, clause 1.5. Works of inescapable nature has been defined. The various works of inescapable nature can be classified as under. Now, Your Lordship, straightway, clause 12. Details of work awarded on the basis of spot quotation should be complied and circle drawn on quantitative basis and submitted to such and such. The engineer in charge, as per his competence, shall proceed to carry out the necessary work and shall immediately intimate PO concerned that such liability is being incurred will approximately almost liability. The competent officer should initiate an action under such and such to regularize the liability. Such emergent works can be executed without call of tenders by issuing work or hand in receipt after collecting spot quotations as per the delegations of power, finance power, diffuser CPW office, spot quotation shall be collected in offices. The condition of bridge was such that it requires to immediate replacement. Clause 11. Plus. Clause 11 is familiar. To ensure transparency and uniformity while declaring the works emergent, the competent authority, CE, ADG, SDG, should record the certificate that the work has arisen all on a sudden, the work is inescapable nature, requiring immediate action that cannot be booked. Book any delay.
Where is the certificate? Where is the certificate?
That will get that report. PDF report টা কত পেজ আছে রে?
It's not urgent here, but both the ministry will make it, okay, more than both is different. The natural calamity.
$104, no? 104, 105 page. Yeah. Yeah, I'm the condition 112 to 12 that also. General condition. Madam. আমাদের লিস্ট অফ লিস্টটা কোথায় আছে?
What is this?
Clause 12 of conditions of general conditions of agreement, which is a part of the agreement.
This is the initial agreement.
Yes, initial.
Road agreement.
Yes.
Road
agreement. Road agreement contains this document.
Yes.
Initial agreement.
Yes.
And now clause 12 is road agreement of 104 page annex first. Clause 12. The engineers in charge shall have power to make alteration in omission from additions or substitution for the original specification, drawing, design, and instruction that may appear to him to be necessary or advisable during the progress of work. And number 2, to omit a part of the work in case of non-availability of a portion of a site or any other reasons, any contractor shall be bound to carry out the works in accordance with the instruction given to him in writing, signed by the engineer in charge. And such alteration, omission, additions or substitution shall form the part of the contract as if originally provided therein, and any altered addition. এখন আমাদের অ্যানেক্সার বইটার কথা আছে Agreement.
Original
Page 99. Yes. The original agreement is at page 99.
Yes.
Now, clause 4 of this original agreement is at page 103. Following documents shall be deemed to form and be ready and constitute as a part of this agreement. BIZ, letter of acceptance, notice of place, that is not required, letter of place not required, condition of contract, general and special. This clause 12 is pertinent so far our case, read with clause 1.5 of the CPWD manual.
But where is the certificate? You have not shown the certificate. There is an objective satisfaction that this is mainly for unseen circumstances, unforeseen, like earthquake or flood, or this is something which is immediate attention is required. And to avoid any kind of misuse, there is a requirement of an objective satisfaction in the nature of a certificate by the chief engineer. So far as clause 12 is clause 1.5 is concerned.
Yes, that is your
11.
DPR report, no?
No, originals of the certificate is necessary.
DPR report to kotha sir? Page? দেখো Millard, for the time being, your lordship may have a glance to at page 129. Sum and substance, if you go through the report, you transfer that this was essential.
Page
129, Annex 10.
Yes.
Relevant page is 130, where the history of this case has been described. All the 6 number of existing bridges situated along the 25-kilometer stretch of Itanagar-Jote Road are in dilapidated stage. These single-line valley bridges were constructed during the early 90s. Are no longer traffic worthy.
This is the DPR.
Yes.
DPR.
Yes, yes.
Page 1 to 29.
Detail estimate. Yes. Dilapidated stage. These single line valley bridges were constructed during early 90s are no longer traffic worthy. The double lane state highway connecting the state capital Itanagar with the National Institute of Technology, NIT, Film and Television Institute, FTI, Jarbam, Gulam Law Colleges, and other premier establishments assume significant ushering overall growth of the state in terms of the Human Development Index and the state GDP. The communication of the state government to keep the surface communication intact and traffic worthy round the clock, therefore cannot be overlooked. This is their opinion, my lord. In exigency, the construction of bridge works had to be started by engaging the same agency, that is Messrs. Such and such, in continuation to the agreement work by such and such date, 10/11/2021, widening and strengthening of such and such road. The same agency has been engaged by this office letter dated such and such, 23rd September 2024, on accord of approval from government number such as 17/9/2024. And anticipation to get the release the fund sanction. The existing belly bridges on Dokoso Nala and Gira Nala have been dismantled, and bypass road opened for vehicular movement. Subsoil investigation, design and drawing for all the bridges have been carried out by the same agency. There is a petitioner blood. Same agency has submitted the report and drawings to this office for the purpose of sanction. For obtaining vetting, design and drawing sent to IIT Guwahati. Pile foundation works have been completed for 2 bridges, VIZ Dokoso Nala at such and such Gira Nala, and the same is in progress from Toma River at 18.376 kilometers. Considering the importance to provide 4-lane connectivity and accessibility of the Jote government, Arunachal Pradesh has been approved the aforesaid project under such and such number such and such. The budgetary allocation has been made available such as super. Hence, this detailed estimate has been initiated and has been for obtaining administrative approval and expenditure sanction from the competent authority. Now, this approval, competent. Now, look at the bottom, method through extended tender. On 197 page, পরে 197 চলে আসি এগুলো পড়া দাও। So whether it is in consonance with the order passed on 11/3/2025 that your lordship will find at page 197. Everything is all right. Now, your lordship, come to clause 12. The clause 12. The execution of work, schemes, projects, and procurement of items, materials, furniture, etc., should be done strictly as per the provisions of DFR. DFPR, CPWD manual, etc. All the financial rules and regulations. The guidelines and directives issued by the Government of India, Ministry of Finance, Government of India Administrative Ministry, Government of India CBC, and Government of Arunachal Pradesh in this regard from time to time should be followed in letter and speed without fail. This is correct. The work shall be carried out through extended tender as per approval of the government by note number 530 dated 7/9/24. Just now I have pointed out. Which was approved by the Chief Minister. My lord. 53079, which was approved by the Chief Minister. Now probably their case is that though it was approved by the Chief Minister, not by the Finance Minister. And this defect came to their notice subsequently. And that led them to issue a corrigendum. And they issued a corrigendum. By issuing this corrigendum, entire nature of the order has been changed. My lord. That corrigendum will
199.
199. Now, what is the content of the corrigendum? The administrative approval and expenditure sanction number such and such dated 18/3/2025 relating to 6 number of double line bridge and ancillary works to Itanagar Jote Road under CM President with an estimated cost of 8750 crores lakh and expenditure restricted rupees 3 lakhs is cancelled. That is the problem. Is cancelled due to presence of some unintentional errors. Now what they want to say, this error was unintentional. Now deleting a portion and substituting by them, by replacing them by new portion, can it be an unintentional error? Rules of executive means that's all. Reporting is also.
Where is this 21/3/2025?
21.
Now, if you are at page 199.
200.
If you read the last line,
Yes.
the now a new approval 21/3/2025. Where is that?
That is a page.
Next page.
Next page, 200.
That is 11/3.
Signing date.
Number is 1965. That was signed on 21/3. Date is remaining same, 11/3, but it was signed on 21/3. According to them, there was a mistake, and that mistake has been rectified by inserting a clause 12. Now, if we go by clause 12, newly inserted, it is a substantial change, my lord. It is a substantial change. You know, it cannot be said that it is an unintentional mistake. Now, clause 12, the execution of works, schemes, projects, and procurement items, material, furniture, etc., should be done strictly as per the provision. This portion is correct. So same. GPR, DPR, DFPR, CWB, etc. All the Ministry of Finance, the Government of India, Administrative Ministry, Government of CBC, Arunachal Pradesh, in these six from time to time in terms of letter and speed. This is the process here. The process of tendering and competing bidding should be mandatorily followed and complied with as envisaged in this. This portion was changed. And by any stretch of imagination, it cannot be said that it is an unintentional error. Now, my lord. What page number?
Page number 197.
197 dekha lo. 197 is the earlier order, my lord. And these order have been changed. Yes, my lord, they can do this thing. Not that they cannot do it. For doing so, my lord, they are to follow the rules of executive business. And there is a specific provision under Rule 21 of the rules of executive business. The rules of executive business. Itu gitu. Bukan gimmick. Ada copy of the extra copy আছে?
Give it back. Yeah. You look at him. Just build this.
Yeah.
You should bring two sets.
But probably the two sets were punished, no? आज आपका पास एक सेट है ड्यूटी बिजनेस का नहीं can you provide it to the board?
Joseph, I have.
This is can hand it over.
Rule 21, subclass 1. When a case has been decided by the cabinet after discussion, there is a rules of convenience, framed under 166(3). When a case has been decided by the cabinet after discussion at a meeting, the minister concerned shall take action and to give effect of the decision. If, however, any deviation is proposed to be made from that decision, the case shall be submitted to the Chief Minister. Now, Chief Minister's opinion has been altered here, below, and that has been substituted by the Finance Minister's opinion, below, submitted to the Chief Minister by the Minister concerned. Here, the Minister concerned will be the PWD Minister himself. Minister concerned, and the Chief Minister shall direct that the case be brought before the Cabinet for reconsideration, save an emergent situation when further action on it will be taken according to such direction as the Chief Minister may deem fit to make. The Secretary of the Department concerned will in each such case cause to be supplied the Secretary to the Cabinet such document as the latter may require to enable him to maintain the record of the case. But what I found, Lord, and probably my learned single judge also observed this thing, not in very clear way, but he has made this observation, Lord, in the impugn order itself. Impugn order ta koto pishta ache? Schedule দেখাবো পরে এখন পরে দেখাবো page 44 schedule পরে দেখাবো page 45. Now this has some bearing with the schedule appointed in this rule, Lord, in the rules of executive business, that is clause 13 of the schedule. Clause 17, page 220 it is. Page 220, Lord. Clause 17. Clause 17 of the schedule, what matters required to be placed before the Cabinet. Proposal to vary or reverse a decision previously taken by the Cabinet. So if we read Rule 21 along with the clause 17 of the schedule, probably the idea conceived by the government was not correct. You can do this thing, but certain observations are to be followed. And this is what the learned single judge has tried to validate it. As page 45, no? Page 45, it starts with paragraph 26. Married. Though the learned additional advocate general has sought to impress upon the court that Cabinet approval was required to be taken, that the approval of the Honorable Chief Minister has been taken after the file was routed through department. The administrative head of the department and the advisor vice Further, the order dated 11/3/25, this is the crux of the problem, which administrative approval of the administrative sanction was given by the government before corrigendum, and even after the corrigendum, my lord. That I will place this order. After the corrigendum is with the concurrence of the finance department. Such being the position, the allotment of works to the petitioner firm cannot be termed to be irregular or illegal for that matter. On the contrary, my lord, in view of Rule 21(1) of the Arunachal Pradesh Rules of Executive Business 1987, read with clause 17 of the schedule to the said rules, proposal to vary or reverse the decision taken earlier will have to be placed before the cabinet. I therefore find force in the argument made by the learned senior counsel for the petitioner. Therefore, upon due consideration of the case, it is entirety the impugned communications are found to be not sustainable and accordingly set aside. The interim order passed earlier stands marked with this order. No, yes, even after the corrigendum issue. Page 200 or something, after 200. Huh? 139. Now, even after the issuance of this corrigendum, another order was also passed on the subsequent date. That is dated 25/3/2025. And it was rectified on 21/3, no?
Yes.
21/3, even after that date.
Are those part of the records?
Yes.
Page?
And that is there, page 139. MRF pesta bar karo.
What is this 139?
और तो पीछे खोटी दवा से हेलो one डेट तो कतो there is in continuation with this letter, Milord, there are some documents and relevant page is 141. I just now pointed out page 139. Now I am taking your lordship to page 141.
Yes.
Milord, here the history of this work has been detailed, Milord. The administrative approval expenditure has been accorded by the government by their sheet number 18/3/25, amounting to
What is the date of this?
25/3.
Where do you get?
25/3 starts from page 139, annexure 12 of the REIT appeal.
No, that way, 141 is separate document, 141.
That is in continuation with the page.
Is it continuation?
Yes, yes.
टेक्निकल संक्शन तो लग अगर सही में लिखा टेक्निकल संक्शन अकॉर्डेड फॉर सेंसोलक्स
That it would reveal from the content of 139. Your Lordship, come to fourth line, 1, 2, 3, 4. Technical lane bridges, ancillary work, road, amount of rupees 7972.65 lakhs, not a reduced. 1,000 only under the head of the such and such. Now, Your Lordship will find the same at page 141. The probable cost now they have reduced 79 crores, 72 lakhs, 65,000. That is the administrative cost they have taken. In the detailed estimate has been made in scope of work, the scope of original sanction estimated, a budgetary allocation has been estimated to the tune of 87 during the current financial year such and such. Hence, the detailed estimate has been initiated for accord of technical sanction from the competent authorities. Next page, 142. नीचे ऐसे बताए The method has been described as page 142 at the bottom. Method through extended tender.
That we have seen.
That is the order dated 25/3 after the issuance of the corrigendum. One case I regret to place before Your Lordship. That is a leading case. Judgment? Huh? Yes, sir, we have. Mm-hmm. 2010, 11 SCC 374. Based on this judgment, our High Court also delivered a judgment. I will not trouble Your Lordship by referring by these judgment, those judgment, because it was on some other context. There's some paragraphs I may read below.
This is MRF.
MRF, Lord. This is a leading case.
Which paragraph?
Paragraph 71. So I will select some certain paragraph only. 71, 89, 90. 71, start let me.
18, 90, then?
71, 89, 90, paragraph 91, 92, 94, '97, 107, 108, 111, and 113.
What is the point involved?
Deviation of contract note. From the month, let's read the paragraph 71. From the combined reading of the provisions of the rules 736 of the business rules of the government of Goa, conclusion would be irresistible that any proposal which is likely to be converted into the decision of the state government involving the expenditure for abandonment in the revenue which there is no provision made in the Appropriation Act or issue involves with concessions and otherwise has a financial implication on the state is required to be proceed only in concurrence with the finance department and cannot be finalized merely at the level of the minister in charge. The process does not stop at this. After concurrence of the finance department, the proposal has to be placed before the council of ministers. Not only that, and or the chief minister. Only after a decision is taken in this regard, it will resolve the decision of the state government. Now, beloved, basically, a government can carry the business or trade in pursuant to their power conferred under Article 298. Question. And that power is executive power. 298. That power is executive power. Now, the executive power has to be exercised by the governor under Article 154. And it has to be exercised by himself or through officers subordinate to him. That is the content of Article 154. And that has to be exercised in accordance with the provisions of the Constitution. So now, what are the relevant provisions of the Constitution? 154. The exercise of power of state. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. Now, your lordship may come. Ministers are the officers subordinate to the governor. Ministers who are appointed by the governor on the advice of the chief minister, these ministers are to be considered as the officers subordinate to the governor. That is indicated in the rules of business minute. Now, your lordship, come to Article 163. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his power, in exercise of his function, except so far as he is by or under this Constitution required to exercise his function or any of them in his discretion. So, governor has to act upon the aid and advice of the councils of ministers. These aid and advice are secured by framing a rule. That rule contemplates under Article 166, which consists of 3 parts. Part 1 is clause 1.
The other part, that certain functions can be discharged at his own discretion. What are those?
There are certain constitutional provisions, that is the 6 schedule provisions. The governor can exercise his because if your lordship goes to Samsar Singh's judgment, Samsar Singh, I've forgotten. Samsar Singh judgment, the Supreme Court had elaborated. Samsar Singh. Elaborated, and subsequent judgment, the Supreme Court has an occasion to say that the illustration made by the in the Samsar Singh are not exhaustive. It is expanding from day by day, my lord. I have not brought that judgment, but Samsar Singh judgment, it is indicated, my lord, that these are the powers which are to be exercised by the governor at his discretion. And so one of this power is laid down in the 6th schedule, probably at rule paragraph 9 or something like that. In the Samsar Singh case also, that is indicated. If required, I can give it. But in this judgment itself, probably this MRF case judgment, this Samsar Singh's judgment has a reference. There are a large number of judgments have been decided. Governor has been vested with certain discretionary power, which is not vested to the president. So the powers which are to be exercised by the governor in exercise as a discretionary power, for that purpose, no rule is required. But so far the rules of executive business is concerned, which requires that the government should act with the aid and advice of the councils of ministers, that rules of executive business has to be framed under Article 166. It has 3 parts, my lord. Clause 1, Clause 2, and Clause 3. Clause 1 tells about that every government order or the instrument is to be issued in the name of the governor. Clause 2 stipulates that there are certain officers to whom the power has been delegated to sign on behalf of the governor. That is the Clause 2, content of Clause 2. Your Lordship, come. Clause 2, 167. Yes. Clause 1 is all executive action of the government of a state shall be expressed to be taken in the name of the governor. Clause 1. Clause 2, there are certain officers to whom the authority has been given to sign the executive order. The orders and other instruments made and executed in the name of the governor shall be authenticated in such a manner as may be specified in the rules to be made by the governor, and validity of an order, instrument which so authenticated shall not be called in question on the ground that it is not an order or the instrument of the executive government. That is not our case. Now, so where Rule 3 is concerned, actually, if we go by the content of Article 163, then the entire matter has to be placed before the Council of Ministers. But in a cabinet system, there are cabinet ministers and there are deputy ministers and there are, what is they called, state ministers. Now, if your Lordship go through the rules of executive business, your Lordship will find 2 terms. One is cabinet and other is Council of Ministers. Executive business. Now, Samsar is by 1972.
1970, Shamsher Singh, will be Lordship noted. Year 1974, Supreme Court 2119. The executive power has been defined.
And some powers, discretionary power, probably if I am not wrong, which are the discretionary power that has been elaborated. And in a subsequent case, the entries, powers indicated in the sum sourcing is not exhaustive. Now, rules of executive business, Your Lordship, at the very beginning, this.
200.
Clause 2F,
200.
page 200. Council means the Council of Ministers under Article 163, which is the aid and advice of the Council of Ministers. So it is a cumbersome process. It would be a cumbersome process if every action, the executive action, has to be aided and advised by the Council of Ministers. So for that purpose, Governor has been authorized to frame a rules of convenience. That is, Your Lordship will find at Article 166, Clause 3. Madam, the Governor shall make rules for the more convenient transaction of the business of the government of the state for the allocation amongst the ministers. And that is why they minister the officers. Otherwise, it would go against Article 154. 154 empowers the Governor to allocate some executive worker to his officers. And by this power, envisaged under Article 163, the Governor has been authorized to allocate some work to the ministers. And thereby, ministers shall be considered as the subordinate officer of the Governor. That will be fortified if we go through Article 164. I will come later in it. The Governor shall make rules for more convenient transaction of the business of the government of the state and for the allocation among ministers. That is in consonance with Article 154. Allocation among the ministers of the said business, so far as it not the business in respect of which the Governor is or under the Constitution required to act is discretion. Discretionary. So, discretionary powers shall be excluded from the rules of executive business. Now, my Lord, Council, now for the sake of convenience, the rules has made a provision that Your Lordship will find rules 2B, Cabinet. We have referred Council, now I am referring Cabinet. Cabinet means the committee of the councils consisting of ministers as appointed as such by the Governor. All the ministers are appointed by the Governor. Some of the ministers will be cabinet ministers and some of the deputy ministers and some of the... Now, so far the rules of executive business is concerned, if we go to the refined rules, it would appear there is a more convenient method has been prescribed. They are specifically Rule 8, Rule 14, Rule 16. These are the convenient. I will not travel Your Lordship, Millard. So this is what I would like to submit before Your Lordship, Millard. So far the learned single judge order is concerned, though it was not specifically as Your Lordship just now pointed, but sum and substance is the content. And it is not that it is a newly borrowed concept by allotting work by extending tender.
But can it be said to be a part and parcel of the original work?
Yes. That can, yes. That, yes.
Certain-
It is a very, very pertinent question. I'm sorry, Millard, I
While
could.
the original work was
153 course.
No, while the original work was allotted, that was work for construction, widening and strengthening of a road.
না ইনি পেজ নাম্বারটা কত আছে? ওই যে
And at that time, the authorities were fully aware that there were 6 bridges.
153. I'm giving, I will take 1 minute time. ওই যে history. 129. Yes. I'm trying to pursue your lordship by reading some lines on
Yes.
detailed estimate.
What are you reading?
I am reading one. Initially, that project was estimated by 153 crores. এটা কোথায় আছে? Huh? That's 153 crores. File noting, no? File noting. 196 or something. No. 110, yes. 110, 113, 1 and 4. One, 110. There's a note constituted by the chief engineer.
What was the original value
Original value was 153 crores. I have to.
of the road?
Road as bridge.
65 crore. Right?
No, the bridge.
153 or 50.
Bridge.
Only the, no, sorry, only the road.
Road and bridge.
5 crore.
No, not the bridge.
Bridge permit was
Original,
reduced.
original work which was allotted to you was for construction, widening and strengthening of the road. What was the value?
The 69 crore loss.
89 crores. Sir?
It's page 99.
69 crore.
69 crore, 55 lakhs, 30,000.
69 crore approximately.
99.
And what is the estimate of the bridge?
80 crore.
No. 80 crores. Now it has been extended.
Can you say that it is a part ancillary to the work? The value of the extra work is even more than the original value.
Yeah, because this is a bridge.
And 2 bridges have already been given to you, not touched.
So,
So
80,
what we wanted to pose to you that you have in very detailed term enlightened on the procedure to be adopted. But how do you take care of the requirement of law of contracts, law of grant of contracts? The law of grant of contracts, the requirement of transparency, which is the hallmark,
yes.
fairness,
Clause 12.
fairness. Why you? Why not somebody else? And maybe you. Why without a competition? You have not addressed these questions at all. You may still do the work, but after facing a competition, there may be better players than you. We are not saying you're not a good player. You're a good player. There may be better player. So without there being a competition,
So that has been
the
allotted.
aspect of public money is there.
That
So far as the
aspect was-
procedures are concerned, you have very elaborately stated that what can be done, what cannot be done, by whom it is done. The chief CM was having the portfolio of whom.
PWD as well as the chief minister.
Committee is more or less, whether it's a committee or it is by CM, almost the same.
Same.
So, but what about the aspects? The first work, original was 69 crore. This estimate is 80 crore. More than
69 plus 80 means 149 crores.
No, that was not one consolidated work. That,
Yes,
that
yeah,
started-
along with the bridges.
That started 4 months after completion of the original work.
No,
That note of the MLA, we are not.
I am also not very much.
Not doubting anything. He, with all good intention, has said, and you can get it done through him. But after a proper procedure.
So whether it is within the prescribed procedure or that is to be looked at.
Yes. But how do you do away with the requirement of maintaining transparency Public money after all.
No, Milord, that is correct, Milord. If you go to page one,
That original case of Sachidanand. What was the Sachidanand, I think? What was stated in Sachidanand? Do you have the citation?
look, here, accordingly, the project, excluding the bridge, was considered under such and such for rupees 89.52 crores.
Originally.
Initially, it was of 153 crores, including bridges. But at that point of time, probably there was a financial constraint. So replacing the bridges were not considered. Say only tender was floated with respect to the widening of the national highway.
From where are you reading this? Yeah, originally bridge was a part of it.
Yes. Huh?
114.
1-1?
114.
114.
114.
Yes.
What is there in 114?
I have that. Type copy. The project of upgradation of Itanagar Jote Sangpua Road of the state highway under Papumpure district
Yes, yes.
was conceived
Yeah,
during
I've read this, I've read this.
original project cost was rupees. Sorry.
Yes, we've seen this.
Well, we have completed 2 bridges and we have carried out substantial work for the other 4 bridges. Assurance bridge, this is we pay the
180.
চলো 118 দেখো না
Just 1 minute.
No. বলো তুমি যা বলবো তাই বলবো আমরা একটু দেখেন দেখো 118 একশো লিখে রেখে
118 ডিসমেন্টেল করতে হবে ডিসমেন্টেল করে বানাতে হবে বানাতে হবে 122
Kandogan. Galing ka kasi nga.
It is another contention. What are the persons?
Beshi bolti hai.
No.
Court में regulation last
Yes.
No, I will just refer to 2 pages only, Millard. One is page after having the approval of the chief minister, but you were at number 530, no? Now, Millard, page 118, 118,
To be clarified again, the approval of the CM was for what?
for extended allotment of the work to the petitioner.
Where is it? Let us see again.
Yes, page 113.
Copy.
That is 113. This is not very legible. You have to read the type copy. You have to bought the left hand side. EU number 530 17/9/2024. CM office.
There is one issue. How can this work be termed as balance work? It is not balance. What is a balance work?
No, that is
If
not
the project,
balance.
Something has been left out. Now, if you come to serial number 5, is 114. Next.
530.
Okay, come to 114, clause number 5.
Inseparable.
114, the type portion. Being
This office has already.
inseparable component of a single project.
Hmm.
It may be inseparable, but how can you term to a balance? If it's a balance work, then it has to be a part of the original work, which was allotted to you, and for some reason or the other, you could not complete or it was not allowed to be completed. Now,
So it should not be balanced. It will be additional work.
maybe, yes, you are correct.
It should be additional work,
And
not
what-
balance.
And once the work was completed on 31/3/2024,
24 and
your relationship as a contractor and the owner has severed.
no, not severe. We were under DLP period.
That is only for the works done.
Work done.
That is only for the works done. But
Yes, that is correct.
the relationship has ceased to exist.
So for the contractual obligations are
Obligation.
for the maintenance of the road.
For maintenance.
Yes, 100%.
Defect period.
Yeah, this is.
Defect liability period.
So this is my case, Millard, and I cannot develop my card beyond the record, Millard. And now, Your Lordship, come to page 118. Even after 118, we have been directed to go ahead with the work, Millard. 118, no?
By the chief minister.
Hmm. Hmm.
118 is.
Yes.
19/9.
19/9/2024. Earlier order was 17/9/2024. It should not be balanced work, it should be additional work.
Point referring to the subject, the approval of competent authority by the CM office.
Arunachal Pradesh, it is hereby conveyed for replacement of dilapidated single lane steel bridge to double lane 6 numbers of bridges conforming to the highway specification. You are directed to take necessary steps to carry out the project at the earliest possible. The original file submitted by such and such division, Doimuk division, consisting of all relevant documents is also referred, returned herewith.
By this letter, what rights?
No, I don't have it. I have not acquired any right. But I was,
Approval has been given. to
that was communicated just when I was directed to carry out this work. As such, my learned friend was absolutely correct that this order does not confer any such right. But I was induced by the.
Is there any document by which you can show that the authorities had directed you to go ahead with the work?
122, no? 122.
That Mr. Tapin has read it extensively and has tried to explain also.
Oh, yes, yes.
Accept it or not a different matter.
Mm,
The
that is-
assistant engineer has said, kindly dismantle the bridge carefully, avoiding any kind of, so out of 6, your good self may start with those bridges which are free. Also, these are all on the aspect of
Having executed the approval order.
groundwork and dismantling.
Mm.
This is not for construction.
Mm.
See, as the undersigned is aware of the fact that you have already started groundwork preparation for construction of bridges in the said road, while assuring coordination, kindly dismantle.
Yes.
But in the meantime, it appears that you have already, might have been tacit approval.
Yes, yes. That is what I can say. I cannot develop my
Tacit
case.
approval
I cannot develop my case.
You could not have started.
Yes, yes. I cannot develop my case by going myself beyond the record. I have to argue my case within the record. It is up to your lordship now.
Okay. Yes, Mr. Tapin.
No, say for some clarification also. So far approval is concerned also. As per the office memorandum, that's the rule of this is a subcommittee, cabinet subcommittee, who has the authority lawsuit. Here lawsuit, we are getting confused with the two approvals. One is the approval of Honorable CM lawsuit in September 2024 lawsuit. And during that time, there was a proposal to get this work to be done by the lawsuit petitioner as an additional work lawsuit. And that went up to the Honorable CM and Honorable CM approved lawsuit. That chapter is up to their lawsuit. Then subsequently lawsuit, that very proposal, how it has went to the cabinet subcommittee lawsuit. Because we have to see that the cabinet subcommittee is the authority. Now he has made approval again lawsuit in the February 2025 lawsuit. After 5 months lawsuit, the proposal was placed before the cabinet subcommittee lawsuit. And cabinet subcommittee has approved the project lawsuit. Now what was the lawsuit, the proposal before the cabinet committee? That proposal was not to get the work to be done by the petitioner lawsuit. If lawsuit see the page, page 48 lawsuit. 40. This is the lawsuit. It starts from note 1 lawsuit. How the proposal was placed before the cabinet subcommittee lawsuit. Here in this very proposal lawsuit, will not find lawsuit if there was a proposal before the cabinet subcommittee to get the work to be done through the lawsuit with petitioner by way of extended tender or additional work.
What is this 48?
48 is the lawsuit, the proposal placed before the cabinet subcommittee for their administrative approval lawsuit. Lawsuit has already noted that earlier lawsuit I have already, yes. Here what I'm submitting is just a 2 approval lawsuit. One is by the Honorable CM lawsuit earlier in the September 2024. Thereafter in the month of lawsuit for February 2025 lawsuit, cabinet subcommittee in the capacity of as a member of cabinet subcommittee, Committee lawsuit, as I've said, cannot be identified with the Honorable CM lawsuit. Cabinet subcommittee do have their own members and it has its own legal entity lawsuit. That needs to be understood lawsuit. Now, what does the error suppose here lawsuit after approval of the by the Honorable
But all said and done, why did you turn around? All along you were trying to get the vote.
Earlier lawsuit, that process was lawsuit, as I've said, lawsuit, it went to Honorable CM.
See, without this approval tacit, may you may call it tacit, can anybody take up the work of such a huge magnitude?
Yes. Lawsuit,
as you acted when? Until the you have gone given the concession for even for 2 bridges.
Lawsuit, seeing the law situation lawsuit.
Now, if it is illegal, it's illegal.
Lawsuit.
But still then, you allowed for 2 bridges.
Lawsuit, when it's at the verge of completion or is completed lawsuit. Under this circumstance lawsuit, no option is left lawsuit because they cannot be undone lawsuit. But what can be undone lawsuit? That we are trying lawsuit. This lawsuit, there are the lawsuit sanction order where it says lawsuit tender is mandatory lawsuit. That is not even under challenge lawsuit in the read petition.
Yes, come again.
That is the sanction order lawsuit page 100 200 lawsuit.
200
lawsuit. Now there's one submission comes from the my senior friend also. This particular clause lawsuit, the first sanction order was issued on lawsuit 18/3/2025. That's at page 197 lawsuit.
Yes.
Where the clause condition number 12 has been lawsuit issued by citing the approval given by number 530 dated 17/9/2024, which is the approval date of the by the Honorable CM lawsuit, but not the finance concurrence given by the finance department lawsuit. Whereas finance department has given concurrence lawsuit by citing a condition lawsuit, you have to go for tender lawsuit. Then accordingly, lawsuit corrigendum has been issued. That error has been lawsuit.
197 was the first approval and sanctions by taking into consideration the approval by the CM at 530.
Lawsuit, therefore, lawsuit, earlier I took lawsuit to the not also lawsuit. Note, kindly come to page 148 again, lawsuit.
148.
148 again, lawsuit. Lawsuit has already noted earlier, but this is the lawsuit proposal placed before the cabinet subcommittee for approval. Page 48 lawsuit.
148.
No, 48 lawsuit.
48. Just now we have seen.
Oh, sir.
Yes, sir.
48 lawsuit. Now, after it has been approved by the cabinet subcommittee lawsuit, page 50 lawsuit, 5050. Lawsuit here, after it has been administrative approval has been given by the cabinet subcommittee at note 11. Hence, the proposal may be put forward directly to finance department for accord of finance concurrence to the tune of rupees so and so.
Yes.
Now, this is the endorsement of the cabinet subcommittee lawsuit.
Yes, yes, we have seen this.
Then lawsuit, it come to page 57 lawsuit.
57.
57. This is the
concurrence
concurrence lawsuit.
Mandate to go
tender.
By tender.
Yes, lawsuit. Thereafter, it was sent back to the lawsuit concerned department. It's a PWD department lawsuit. And PWD department, what they did at page 61 lawsuit.
Yes.
The
note number 40.
Principal Secretary, 48
Note
lawsuit.
48.
Yes, yes. As per the finance concurrence, the condition given by the finance concurrence. Then page 62 lawsuit. What they did lawsuit? They inserted lawsuit while issuing this page 197 lawsuit. They inserted lawsuit the another condition, which is not in consonance with the finance concurrence given by the finance department lawsuit. Therefore, this direction was given to correct it again.
Page 57 is dated 1/3/25. What is the date?
Page 50,
57.
57 is dated lordship. Date is at page 60 lordship.
1/3/25.
No, 11/3/2025.
11/3, sorry, 11/3/25.
Yes.
And 197, same date.
Same date,
197.
same date, 11/3. Signed on 18/3.
No, sign is on 18.
11/3 signed on 18/3.
Signed on 18th.
18/3. And rectified on 22/3.
Because by this lordship,
So that means you say that the endorsement by the finance department made on 11/3/2025 was somehow not taken into consideration by the department, which had included the terms extended tender
correct.
on 18,
18.
though the letter is 11/3.
Correct.
In the sanction order by PWD at 197, is there any reference to the concurrence by the finance of 11/3?
The second, the
197, kindly show us.
no, in 197 lordship,
Yes.
kindly come to page 198 lordship. This is issue bottom lordship. This is issue in concurrence of finance department by number computer science and so and so.
Date
lordship.
let's see, 48. 57.
197
Let's see, 57.
Date.
মানে ফাইন্যান্সিয়াল কনফারেন্স আছে কিনা দেখা আছে কোথায় নয়
What is the?
Therefore, lordship.
Just a minute. FD computer number, file number 411. What is the file number here? FD
1635
1635 in 197.
Kindly come to page 57 lordship. In 57 lordship, you will find the computer number down below.
Down below.
Yes, this is 223522, and exactly lordship will find the same number here in page 198 lordship. The computer number 223522. This sanction order has been issued in deviation from the conditions given by the finance department lordship.
বেটা গিয়া হওয়া ভাইয়া আমাদের শিডিউলটা যা পরিশ্রম করে বাজেটটা ছুটে যায়
Okay. 197 out of 187. Okay, this public notice of extended tender it will issue in conference with finance department next page. Finance department conference finance department conference order, right? The page 7. What is 57? 57. If a computer number.
21.
And then go for There are 10 and 12. There are 10 and 12. So two prohibited are 10 and 12. There are 10. Or 12 also. Word last part. The process of tendering and competitive bidding should mandatorily be followed and complied with and received by so-and-so. এইখনৰ মতে PWD সেই কম্পিউটাৰ এইখিনি পাঠ কৰিছে আৰু এইখিনি বস্তুটো প্ৰমাণ কৰিছে আপোনাৰ কম্পিউটাৰ নম্বৰটো 235522 কম্পিউটাৰ নম্বৰ এটা আজিকালি নোটবিলাক হেৰি ইলেক্ট্ৰনিকেলি হয় না ফাইলবোৰ ইলেক্ট্ৰিকেলি 120
Executive business.
Public Works Department has not followed the Finance Department's.
Exactly, Lordship. Exactly, Lordship. Therefore, Lordship,
Instead of saying that it has been, the order has been issued in concurrence, after concurrence order by the Finance Department. Finance Department at paragraph 12 at page 58.
Therefore, Lordship,
had very categorically said the process of tendering and competitive bidding should mandatorily be followed and complied with as envisaged in the GFR. So.
Correct.
Yet this Finance Department had referred to an earlier approval made in the file at paragraph that 10 or something and had ignored this requirement.
Lordship, therefore, corrigendum has been issued, Lordship. And correct sanction order has been issued, which is in consonance with the
Financial.
cabinet
Cabinet as well as Finance Department.
Finance Department, Lordship. That is page 200, Lordship. And my senior friend has submitted, Lordship. Even if this correction is to be done, Lordship, then it has to go to the cabinet, Lordship. That's what he has submitted, Lordship. What I'm pointing out is, Lordship, this 197, the past sanction order, is not in consonance with the Lordship cabinet decisions and the Lordship, the finance concurrence, Lordship. So therefore, that error has been corrected by issuing the second sanction order at page 200. The executive business rules. No, your. Records.
Just a minute.
हाँ ये तो दिखा दिया वो दिया कितना बार दिखाएगा दो बार दिखा चुका है इसका
Oh, yeah. Oh, there you go.
ऑलरेडी उसको पता चला है and Lordship
just a minute. Yes.
Lordship, the second sanction order, Lordship, which we have, after review, Lordship, we have issued in consonance with the Lordship term of the Cabinet Subcommittee and Finance Concurrence, Lordship. Dear Lordship, it's mandatory that Lordship, it has to be, work has to be awarded by tender, Lordship. And that is not under challenge in the writ petition, Lordship.
Where is the writ petition? The prayers in the writ petition.
Writ petition. Kindly come to page 66, Lordship.
No, 94, I think, writ petition.
Writ petition
94 is the prayer, isn't it?
94, yes. Correct.
What is 29/3/2025?
29. This is stop order, Lordship. The impugn order by which, Lordship, we have decided, Lordship, two work of yours will regularize.
Remaining 4 by tenders.
By remaining.
This is the subject matter of challenge.
Challenge, Lordship. And sanction order is not challenged.
And what is 24/4/2025?
That also is the same, Lordship. We have directed. Basing on that sanction order, these letters were issued, Lordship.
Okay. What was the order which you have said that the decision to after review was not challenged? That decision is dated?
Lordship.
You had said that the decision after review to go for tender was not under challenge. Which decision? This
Sanction order, Lordship.
sanction order.
Sanction 200, Lordship. Page, kindly come to page 200, Lordship. And it's dated 11 March only, but it's signed on 21 March, Lordship.
Yes.
Page 200. This is second sanction order, Lordship. The corrected one. Corrected sanction order. In condition number 12, Lordship will find exactly what the finance department has given the condition was.
One is 197, other is 200.
Yes, correct.
97 is one in our favor, 197. That is.
But all 11/3, same date.
Same date.
But signing date is
By the same date, two orders were placed. One is 21 and one is the 23. Yeah, even after issuance of this order, we were directed to go ahead in the case. A lot of anomalies are there.
What were you submitting before this? You're submitting something?
Lordship.
Subsequent, his commission subsequent order was not challenged.
No, that we have noted. Before we had asked this question. Before that, you were submitting something relevant. Then we interfered. Which order?
Lordship, I was on this sanction order only, Lordship.
Yes.
The subsequent
Corrected sanction order, Lordship.
Yes.
Second.
The sanction order is page 200.
Close to it. It's not under challenge.
No, that you have said. That we have asked. Just before that, you had said. Twenty-nine. Where is 29/3? That order?
29/3.
29/3 was in our favor.
Impugn order at 144.
Impugn order.
Where two Docoso and Geranala have been allowed to continue, and 4 will go for.
Yes, 144 page.
At 144.
Yes, boss. And this is in consonance with the lordship cabinet decision and then finance and then sanction order lordship, the corrected one.
Yes. Okay.
Then lordship, the work of inescapable nature lordship, as it was pointed out lordship. Lordship, for that also lordship, sport quotation has to be there lordship. Order has to be issued. CPW manual says lordship. The engineer concerned has to certify that this particular work is in case of lordship urgency lordship. And what are the lordship the urgent nature of works lordship, for which lordship this particular without floating tender by way of work order or sport quotation can be given. Itself, it has been provided 1.5 lordship, as my senior friend has pointed out lordship.
1.5 means?
CPW manual.
CPW manual lordship.
Yes, yes.
Here lordship, certain works are given lordship. And to my understanding lordship, what it says, my senior friend is skip this particular clause 1.512.
One minute. This is the one? No, no, no. Okay. One point?
This is 1.5 lordship.
Yes. What do you want to what do you want to read?
Here lordship, works of inescapable nature, which can be lordship awarded by without floating tender, by work order or sport quotation lordship. Now works are given here lordship.
Yes.
Nature, earthquake and all lordship. Here lordship will find in serial number 2. The other causes like explosion, arson, fire, war, sudden collapse of building, oblique bridge. If there is a sudden collapse of the bridge, if there is a collapse of the bridge, it comes under this particular category. Otherwise, not lordship.
There's no collapse of the bridge.
Here case is not a collapse of the bridge.
Clause 10 is.
Then kindly come to clause 12 lordship. 11.
10 also.
11. To ensure transparency and uniformity while declaring the works emergent, the competent authority, that is so and should record a certificate that my senior parent. So he has. There must be a certification lordship, and then lordship. Then how it has to be awarded lordship? Such an emergent work can be executed without call of tenders by issuing order or on hand received after collecting spot quotation as per delegations of powers given in financial power delegated to CPW officers. Spot quotation shall be collected by officer not below the so and so and so. But here, that these all exercises.
See the rider, see the caveat.
No, sir.
In ampersand, within brackets, within ampersand. Normal works which require compressed schedule for completion early start should not be considered as emergent works.
Close.
So the purpose of having this is only for exceptional circumstances.
Exceptional circumstances.
Old bridges needs dismantling, new bridges. This would not come within this. If the emergent situation should arise that the bridge is about to collapse or collapse, yes, there is a report. It has become dilapidated. It has become risky. But will it require that you do away with the process of tendering, or you go for immediate work order or spot? What do you call spot?
Inescapable nature.
Spot quotation.
Spot quotation.
Quotation. All this exercise is missing in the present case laws.
Oh, exercise is also missing.
And secondly, lordship, there's no collapse of the bridge, lordship. Dilapidated condition, lordship, is not the part of this particular.
Yes. Okay, we'll consider.
And next is lordship, this particular, the rules of executive business lordship. The rule 21 lordship. Just allow to read it again lordship.
Yes.
When a case has been decided by the cabinet after discussion at a meeting, the minister concerned shall take action to give effect to the decisions. If, however, any deviation is proposed to be made from that decision, the case shall be submitted to the chief minister by the minister concerned, and the chief minister shall direct that the case be brought before the cabinet for reconsiderations. Save in an emergent situation, where further actions on it will be taken according to such direction as the chief minister may deem fit to make. The secretary of the department concerned will in each such case cause to be supplied to secretary to the cabinet such document as the letter may require to enable him to maintain the record of the case. Now, on this particular point, just my submission is that, Lordship, there's some misconception here, Lordship. What it says, Lordship? There says, Lordship, decisions of the cabinet, Lordship. This is more on the policy, Lordship, policy decision, Lordship. And so far the present case is concerned, the delegations of the financial power, Lordship, this is purely an administrative, Lordship, action, Lordship. It does not come under the Rule 21, Lordship.
It's not a cabinet decision.
It's not a cabinet decision. It's a purely an administrative action and a policy decisions. That's completely different from each other, Lordship.
Construction of a highway or a bridge is not a cabinet decision. It's not a cabinet decision.
Without having
a cabinet decision, all right? Administrative.
Lordship. Here, Lordship, because that who is to be given the power, that may be a policy decision, Lordship. But once it has been given, the action carry out the policy, that's an administrative. That will not come under the Rule 21. That's the one part of submission. And other part, Lordship. Here, Lordship, the review, here, by issuing the second corrected sanction order, non-deviations or has been done in respect of the cabinet decision, cabinet decision and the finance concurrence laws subcommittee. Suppose, say, by issuing any Lordship sanction order, if I'm deviating from the decisions of the cabinet subcommittee or finance concurrence, Lordship, then obviously I can't deviate from their concurrence, Lordship, approval. Here, case is not that, Lordship. We have rather corrected in terms of the Lordship decisions of cabinet subcommittee and the finance concurrence, Lordship. We are simply correcting the Lordship, the mistake done by us by issuing the first sanction order, which is not in consonance with the cabinet subcommittee decision and finance concurrence laws. So there's questions of Lordship, deviation. What section, this Rule 21 says, if you are deviating from the decisions of the cabinet,
Yes. That is the case.
then it has to go to there. But we are not deviating. By second sanction order, the corrected one, we are in consonance with that has been issued in terms of the condition given by them only. So where is the deviation, Lordship? And thirdly, Lordship, the so far the 153 crore, the earlier original, this is only the mine only, Lordship. Mine has been expressed while writing the history. But until unless the proposal is given the legal shape, Lordship, that will not, Lordship, have any meaning. That's my understanding, Lordship. The original proposal, that's all, Lordship.
I beg your Lordship, pardon, Lord. Just I would like to point out one point, Lord. Now, Lord, any decision which is not aided by the decision of the Council of Ministers will not constitute an executive order. That is the mandate of Article 163. Now, my learned friend is saying that this is not a cabinet decision. Without having a cabinet decision or without having a decision of the Council of Ministers, no executive order can be germinated, Lord. If we go through the Article 163, it is very much clear. So if you want to alter the cabinet decision or the decision of the Council of Ministers, it has to be placed before the cabinet or the Council of Ministers, as the case may be. And there is a specific provision in this regard. I'm not saying that you cannot debate it. And that is the content of the learned single judgment, sir. Without having the decisions, aid and advice of the Council of Ministers, no executive order can.
The point, a single judge has not said so. Where is the single judge?
Yes, the single judge order is specifically stated.
No, no.
Page 45,
Let us see this.
paragraph 26.
We have read that.
And single judge has pointed out that yes, you can do it, but for doing so, you have to abide by the procedure as contemplated under Rule 21. And I don't find anything wrong.
What we are just loud thinking that the Honorable Single Judge has justified the action or had concurred with your submission in the Red Court on the transaction which has happened in this. But the substantial law on this field, that there is no discussion to that.
Yes, to some extent correct. To some extent correct, but if we go minutely, Milord,
If you go by the
content of article,
go by the exchange of communications and in this entire thing, Honorable Single Judge has taken note of that and said that under these conditions, this allotment of work may not be termed to be irregular or illegal. That is qua the transaction which has happened in this case.
Yes, yes.
But what about the law?
Now, Milord, learned
Law
single judge,
distribution of state largesse.
whatever may be, distribution of state largesse is concerned, but it must be in consonance with the rule of law.
Yes, that is exactly what we are trying
That must be.
What is the rule of law?
Yes, yes, that is must be concerned with the rule of law. What is the rule of law? Executive order, sorry, rules of executive business.
The rules of executive business is only a means. Only a means. But what is the rule of law? What are the principles of the law regarding distribution of state largesse?
No, that was not their case even, Milord.
No, that is the case where you find the page 200, page 199 and 200. That has been emphasized. All tendering, competitive bidding required. It's mandatory. That is the law.
No, that is tendering process. That is the law as per the finance minister's concern, Milord. And our order was passed as per the approval of the chief minister. There is a apparent conflict between the opinion expressed by the chief minister and the finance minister. Now the principal secretary, the PWD minister, has rectified this order. That was taken in consonance with the cabinet decision, rules of executive business. Without having the opinion of the council of ministers, no executive order can be.
Okay. It is based. Heard Sri S. Tafin, Leonard Senior Advocate for the parent. Also heard Sri A.K. Assistant, Leonard Senior Counsel assisted by Sri S. Doctor for the respondent number 1. First respondent.
Yes, full respondent.
So, respondent with petitioner. Hearing is concluded. Judgment is reserved. Yes, we'll consider.
No, we have completed 2 bridges, and so far the other bridges are concerned, we have done substantial part of the work.
Done on the basis of work orders.
Yes.
Work orders.
We have done.
For the others also.
Yes.
Work orders issued.
No.
How can there be work orders?
No work order, but we have carried out certain work orders. Page 120.
120. What is there? 120.
Pursuant to the approval of the competent authority.
Yes.
That is an order dated 23rd September 2024. After the order Prime Chief Minister's approval dated 17/9/2024. Pursuant to the approval of the competent authority by UA number 530 dated 17 September 2024, you are requested to immediately carry out subsoil investigation for 6 bridges substituted at various locations of this highway conversion from the existing single lane of bridges to the double line bridge and conforming with the national highway specification. And so for the so far the UN note number 530, the extended tender system. And we were the tender handler.
No, last paragraph.
Yes,
The work shall be taken as additional work under the existing agreement subject to approval of BOQ and technical section. Determination of workable price shall be based.
That is submitted.
But after this, we have the letter of the assistant engineer, which have allowed it to dismantle. That is 2011-2024. This cannot be construed to be work, but nonetheless, will construed.
240, no? Yes, there are some anomalies, I admit, Millard. 240, page number.
Yes, what is there?
Status report, Millard. It is not that there are no anomalies, Millard. Yes, there are some anomalies. Construction of 6 number of double line bridges and ancillary works on Itanagar Jodh Road. Submission of the status report thereof.
Yes.
This is the status report. Yeah, Burger, bridge over such as earthwork execution completed, 40%. Then bridge over.
Now it is completed.
Now it is completed.
The 2 works which you have done, those have been completed.
The 2 have been completed, and so far the other is concerned, we have completed 40%, and 20%.
1 and 5 completed.
1 and 5 completed, and we have substantially carried out the other bridges. That is the problem.
Okay. The rest may not be possible today. Division bench obviously not, but single bench also. Court master will have to give dates. Mr. Mark, sorry. Maybe it's tomorrow. Is it urgent?
I said, my lord, it is there, a small matter, but it has been held up for more than a year. And Lordship is aware of that mandate, legal mandate is 30 days. Application under section 11 should be disposed of under arbitration and conciliation. This is pending. Now,
Who's for the other side?
other side is someone is here, my lord. My friend from this bar only.
State is there.
Item number 3. Private
Is there or who's there?
No, private respondent.
Tomorrow, we'll not know how. We have not seen the list. We can try.
Yes, my lord, it comes
Try
up.
for tomorrow. Okay?
Or if
May it please your lordship.
I don't know what-
Similar is, I would say, in respect of item number 8 to 10.
8 to 10 will take time.
The single, it's an election matter, my lord. Concluded election results have been stayed at the
Elections for?
Arunachal Cricket Association. Elections were held, but by the Supreme Order, we have filed application for getting stayed.
Who's for the other side?
He appears for the other side. He was here.
Okay, we'll try tomorrow then. Tomorrow.
May it please your lordships.
Yes, it will. Yes, well. Yes.
Lordship, may I please mention item 13 and 14?
Yes.
May I humbly pray for the matter to be fixed on the 9th of June, please? Item 13 and 14.
Yes.
Lordships, we
9th of June, yes.
deeply obliged to your lordship.
And you're appearing in person, what do you want?
My
Your
lord,
matter?
Lordship.
item number 15 and 16, my lord.
Of DB matter?
Yes, my lord. 15 and 16, my lord.
When-
May I pray
when-
for 18th, my lord?
8th.
18th of June.
18th.
1/8. 1/8.
1/8. Okay.
My lord. Obliged.
May I please, Sir Lordship, my item number is motion in item number one. So it's, yeah, yesterday it was fixed and again it was fixed today.
Yesterday, what had happened?
There was some error in pagination. So they have, today it was fixed again. So I have.
We can have it tomorrow.
Oh, obliged, Sir Lordship.